Welcome to Classic Trials. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we make sense of the law one bite at a time. In this series, we observe and analyze the play-by-play of some of the biggest trials that have shaped the public consciousness of the American judicial system. In this season, we're working our way through the case of California v. Erik and Lyle Menendez. Growing up in Princeton, New Jersey, and then Beverly Hills, California, these young men had everything they could ever want, or so it seemed, until one night on August 20th, 1989, they approached Jose and Kitty Menendez with newly purchased shotguns. Put on trial for murdering their own parents, they claimed self-defense, arguing they were terrorized in their own home by abusive parents until they could take no more. Which argument is more convincing? Come join and see for yourself. Hello, hello. Good morning, good afternoon, good evening, and a happy Monday to everyone. I hope you're having a great day and that your week is off to a good start. Hope it was a good weekend. So we are through with the current trial or the more current trial. I guess it's now it's over, right? Of Gwyneth Paltrow versus, Terry Sanderson versus Gwyneth Paltrow. And now we're back to our usual program, which is Menendez Mondays. It's another Menendez Monday. So yeah, we're going through the Menendez trial as part of our classic trials. And it's going to be another probably 3.5 hour sort of piece of this trial, which it's so long. So we'll see how long this is going to take us to get through this entire trial. But back by popular member demand, I should say, because there are a lot of folks that always ask me, when there's a little bit of a break for Menendez Mondays, there are folks that write to me that they're like, I want to know what happens next. So I hope you guys are doing well. Let's say hi to some folks in the chat. Elise Lynch says, I've got an early appointment today, so I will miss most of this, although I won't miss Dr. Oziel. Hope you're well, Squirrel. Elise, I hope you are doing well, and I hope that appointment goes well. So I guess we'll catch you on the replay. Living life with and singing songs with Mallory says, hello from Santaquin, Utah. Or is it Santaquin? I think probably Santaquin. About an hour south from where Gwyneth Paltrow's trial happened. I hope Alita in chat had a good weekend. Thank you. I hope you had a good one as well. Shireen, thank you for doing your mod duties. Every like gets the squirrel some more nuts. More nuts are good. Nuts are also good. So happy to see the mods in here as well. Thank you so much for doing all the great stuff you do for the channel. Mary M, greetings from Munich, Germany. Greetings. Mark Taylor, I know how this one ends. I know this is where we really should start every episode with a spoiler alert, because there's always people in the chat that know the end, and inevitably stuff comes up when we're talking that, I mean, people basically know what happens, at least if not at the end of this trial. Well, when you know that there's two trials, it's a criminal trial, you can kind of deduce what happens in the first one. so there's that. Let's see here. Moving on down. Hi guys, from Debbie Faison Cook. Hey Debbie, I hope you're doing well. Donna Grace. Hey everyone, hope you are well. Let's see here. KP, hello from Texas. Hi KP. Or should I say howdy? Jenner G says hello. Tony P, yay, good morning. Good morning to you. Gamer Ducko, thank you for the blue heart. Doesn't translate to StreamYard, but we can use our imagination here. Otterly Bell, hey y'all from a sunny Sweden. Still sick though. I hope you're feeling better soon, but happy to have you here nonetheless. Melissa Simok, happy Menendez Monday. I totally messed that. I butchered it. Happy Menendez Monday. Good morning, everyone. And I missed the hashtag. See, it is a Monday. It is a little bit of a Monday, isn't it? Nicole Christine, morning, everyone. Watching from Austin as always with my coffee. Awesome. No spoilers, says Secret Mix Squirrel. Mark Taylor, I wasn't going to say anything. Oh, man. Yeah. Debbie Faison Cook, it's not as stressful when you know. Yeah, right. Gwendolyn SS, good morning, everyone. Good morning to you. Cheryl C says hello. Cheryl, hope you're doing well. Mark, yeah, I knew how Titanic ended, but the movie was still good. See, good point. That's a very good point. We can still watch it and digest it and dissect it and whatnot, and hopefully have an entertaining and educational experience all at the same time as well. Secret Rick Squirrel doing her mod duties. Thank you so much for that. So, yes, if you guys are enjoying it, do hit the like button. If you aren't subscribed, do subscribe. It does help the channel grow. So, and more likes on the video means that it'll get placed in front of more people potentially. So, always a good thing. Plant Freak, good morning from Canada. Good morning to you as well. Hey, Nick Wilson. Hey, everyone. Not feeling great today. My dizziness is bad today. I'm sorry to hear that, but hopefully, this will be a relaxing enough experience for you that it'll be a little bit helpful for you. Christine Kyle says, morning from Philadelphia. You're the background of my morning workout. Awesome. Get it. Get more reps. I got my workout in today and it was a good one. It was a good one. It was a good start to the week. So hopefully yours will be also a good solid one to start the week too. Nick Wilson, after 14 years, finally been referred to neurosurgery at last. Oh my gosh, that's a long time to wait. It's a very long time to wait, but hopefully that means you'll see some good progress. Alrighty. Okay. So shall we get into it? Shall we get into the trial, back to it? Okay. So I know it's been a couple of weeks, right? Because, or was it a week before last that we last did it? I think, yeah, I think so. I think we just took off 1 week for the Gwyneth Paltrow trial. So for anybody that isn't familiar, or for those who have forgotten in the interim, we are in the middle of the Dr. Oziel testimony. So Dr. Oziel is he's the psychologist, or the clinical psychologist who was treating the brothers, or at least one of them, when they allegedly, I say allegedly because at this point in the trial, it does seem like the defense is still kind of disputing whether or not they admitted these things. They're trying to get whatever points they can on cross-examination. But anyway, Dr. Oziel says that they admitted to him that they had killed their parents, and so he then reported them. We've already gone through the whole doctor-patient privilege waiver and all of that kind of stuff. And then last week we got into some really spicy stuff. I don't know if you guys remember, but there was a whole thing about the girlfriend, and then he told his wife and kids to stay at a neighbor's house, and he went to the girlfriend's house. And his justification for staying with the girlfriend, as opposed to with his wife and kids elsewhere, was because he didn't want to put his wife in danger, or his wife and kids in danger. But then I guess it was okay to put the girlfriend in danger. And then there were like, it was so weird, the things that he was like relying on in terms of his reasoning. Like, he was talking about how there were a lot of letters that he had kept from her, where she like passionately talks about how much she sees a future with him or something like that. And then there's like other like business venture deal paperwork, I guess, that they had together. There was just a lot of weirdness. And so I expect the weirdness to continue. I did see in the description for today's portion that there was a mention of a recorded phone call between him and the girlfriend. So we'll see. We'll see how that goes. But I think this is all going to be entirely cross-examination. Whenever we do these, by the way, I don't pre-watch them. I go through them enough to be able to skip through the ads when we watch them together, so that And we're back. Okay, let me see if this is working. Okay, there we go. All right, what's a Legalbytes live stream without a little bit of internet issues? Okay, hang on. And now I'm hearing sound in places that I shouldn't be hearing it. Hang on. I'm hearing myself and I shouldn't be. There's something going on here. One sec. Okay, let me try this. One sec. I love it when this happens. Okay, but now I open that up again. Okay, let me see. You know what? I'm just going to close this. Okay. Okay. All right. Here we go. Oh, wait, no. I still hear myself. This is awful. One second. Let me refresh real quick. I'm sorry, guys. Okay, I figured it out. You know why? It's because okay, sorry. I could hear myself even though I had it muted on. Like I always have the live stream pulled up, and it was because my earbuds plugged into my phone and not to my computer. And so anyway, so I was hearing myself on the live stream, even though it was muted on my computer. Anyway, it's kind of a weird thing to explain. So I was hearing my voice 10 seconds after myself, and I was very confused. It was because it just my earbuds connected to my phone, and I was just like completely oblivious. Like, what is going on? What's happening here? Okay. Anyway, all right. Now we have that figured out. Okay. Now let's get back to business. All right. It's a Monday. Okay, so yeah, so there was a lot of weirdness coming out during that last cross-examination. That was all Leslie Abramson. And so now I think we're going to be hearing more from the other defense team, and we'll see how it goes. We will see how this all goes. Okay. All right, let's get to it, shall we? All right, we're like 15 minutes into the stream. Maybe we should actually like watch the trial itself, right? Okay, let's do it.
In the trial, the defendants are both in court with their attorneys. The people are represented.
That's why.
And both juries are in the courtroom. Welcome back, ladies and gentlemen. And we're ready to resume with the trial. The people still have a witness on a witness stand being cross-examined. Dr. Oziel, would you get back on the witness stand, please?
Can everybody hear okay? Are the volume levels okay?
And would you state your name again for the record?
Dr. L. Jerome Oziel.
All right, I'll remind you that you're still under oath and the cross-examination by Mr. Burt.
Sir, I'd like to start with just briefly reviewing some of the chronology here so that we have fresh in our minds some time periods, okay? You have in front of you the ledger cards
Yes, I do.
and also your appointment book.
That's correct.
Okay, could you,
Is that 97, 98, 99?
yes. Could you look first at the ledger cards, Dr. Oziel? Just to refresh your memory on some dates here. Is it true that you first began seeing members of the Menendez family on September 30th, 1988?
That appears to be the case.
And do you recall on that date who it was that you saw?
I believe that I saw Jose and Kitty Menendez, not as patients, but telling me about.
Okay, just,
I'm sorry.
the question was, who did you see? You can answer that by names.
Okay. Kitty and Jose Menendez, and I'm not clear on whether I saw Erik or I did not see Erik the same day.
All right. And on that date, is it true, according to your ledger cards, that you billed $150,
Really looks like a bad guy
which
from
would have been, I
Ghostbusters
think,
without his
justified for a
glasses.
45-minute session, correct?
That's correct.
Right. Does the ledger card reflect when you first had a session with Erik Menendez?
The first named session with Erik Menendez appears to be October 4th.
And you billed $250 for that session, which according to your ledger is 1 1/4 hour, correct?
That's correct.
Right. And on the same day, after you had your session with Erik, did you then have a consultation with the parents?
That's correct.
Now, how is that reflected on the ledger card?
Well, it appears to be just M and M double. I mean, I'm assuming that that's what that means. I didn't write this.
All right. What it says is 10-4 and then M/M DBO.
Yes.
Are you saying that what that probably represents is mother and father for a double session?
That would be my best guess about what it represents. That's not any terminology that I would have ever used, and my secretary has apparently wrote that.
And that was Sandy who
That would,
probably wrote this?
yes, that would be correct.
She handled all of your billing, is that correct?
Most of my billing.
And that session or consultation with the parents took place after you had had a consultation with Erik Menendez. Is that right?
I believe so. I don't know if it did. There's no way for me to know whether it took place after or before. It could have taken place before. She could have just listed it later. I have no idea.
And
Don't know.
you billed the parents $300 for that double session on the 4th, correct?
That's correct. That appears to be correct.
Now, when is the first time you saw Lyle Menendez?
Appears to be 11/2.
Okay. Do you want to look at the entry 10-5?
Oh, sorry. Yes, it doesn't say Lyle. It says older son. Yes, that.
As far as you know, is that Lyle?
Yes, that would be
And
Lyle.
that would have been the day after you saw Erik and the parents, correct?
That's correct.
And you billed him $500, which is 3.5 sessions, correct?
I don't know if that's 3.5 or 3 1/3. Looks to be 3 1/3 sessions. I don't know.
In any event, you billed him $500 for
That's
that
correct.
session. And then is the next entry after you saw Lyle, you again met with the parents on October 12th, 1988.
That's correct.
And you had a double session with them where you billed the parents $450.
Well, yes, that looks correct. Mhm.
And then after that session, you met with Erik on the 14th and the 25th of October 1988, correct?
That's correct.
All right. And then continuing on through the end of 1988, you saw Lyle on November 2nd, November 16th, correct?
That appears to be correct.
And for those sessions, you billed him $150 per session.
That's correct.
And then he had an appointment on the 29th of November 1988, but he didn't show up, correct?
That's correct.
And you saw him on December 2nd, 1988.
Appears to be correct.
You billed him $150 for that session.
That's correct.
You saw him on December 9th for a $150 session.
That's correct.
You saw him on December 14th for another $150 session.
Appears to be correct.
And then continuing on the next page of that exhibit, you saw him on the 17th, the 18th, and the 24th of January 1989, correct?
I'm assuming that's correct. It says L, so
And there's a notation on the 24th indicating at that point that Lyle was going back to school, correct?
yeah, it looks like that. Yes.
You billed him $400 for that session on the 24th.
Appears to be correct.
And for the 18th and the 17th, you billed him $150 per session, right?
Appears to be correct.
And after you saw him on the 24th, is it true that the very next time you saw Lyle Menendez was when you consulted with him on December 23rd, 1989.
December 23rd, 1989. I'm trying to find that here.
Excuse me, August 23rd,
Oh,
1989.
August 23rd.
Yeah.
Okay. Yes, that appears to be correct.
And you, on that date, on the 23rd, billed $450 for a consultation with both Erik and Lyle, correct?
Correct.
And on the 24th, you again saw them, and according to your ledger, it was one half Erik and one half Lyle, correct?
Technology's advanced a lot, right, Mark?
I believe that that's the one half Erik and one half Lyle. It was their agreement as to how to divide the bill. It doesn't necessarily reflect the amount of time that I spent with each of the individuals.
In other words, you could have spent 3/4 of that time with Erik, 1/4 with Lyle, but they'd each pay half the bill.
Ooh, that
They
feed
just
is getting
agreed that
snowy.
that's how they wanted to handle the bill.
And on August 24th.
Is this one at home? Everyone would have to like adjust the bunny ears on the
You had
TV.
8 sessions plus 1/2 hours, correct?
That's correct.
And you billed them $1,300.
That's correct.
And was that the occasion where you went over to the Bel Air Hotel
That's correct. It's best my recollection.
and spent the whole day over there with him, basically?
8 sessions would not be a whole day, but it would be the better part of a day.
And you were billing them there not just for private consultations with them, but also discussions with the family, correct?
Well, what I was billing them for was consultation and my time, which is just my practice, whether I'm spending a day in court with somebody, if in fact they want me there, or if I'm doing psychological testing, I bill for my time. So I'm just billing for my time and the consultation.
All right. And did you, I think you
Aaron,
said
I'm gonna save this
after
question
the
for a
hearing,
minute.
you were the one who called them, correct?
Yes, I called them to ask if they were okay and if they needed or wanted in any way to talk to them.
And do you remember when that phone call was made? What date?
Oof, this is getting rough.
Is that reflected on the billing?
No, I don't believe it was.
And they indicated that they wanted.
Oh,
to
boy.
talk to you, and then we went over to the bank.
They specifically requested.
You know what?
I don't know if it was Erik.
Let me skip ahead a little bit.
Alone, correct?
There we go.
For 4 sessions.
4
Mhm.
sessions.
I'm sorry we didn't get those questions, but
On
realistically, we were
August-
not gonna. Oh my gosh! Ah,
You made your
good lord.
date that,
Okay, hang on.
And is it also true that
This is so rough.
$150?
Correct.
And actually had a session with him on that.
Oh gosh. Oh no.
It looks to be.
I much prefer to be actually like sitting and watching the testimony, but if it's going to be this snowy, it's going to be very distracting, and we probably won't be able to see and hear it anyway.
December 20th. Can you read that?
No, it looks like it's 12:20. Are you talking about?
Yes.
Yeah, 12:20. Lyle no show. Is that what you're?
No, it says 1220 Lyle DBL, which is a double
Abuse,
session.
No, that was
I am old enough. I was
12:22.
little, but I do
12:22.
remember.
Looks to be.
I do remember.
So you
seeing
met him
them.
on December 22nd for a double session, and you billed him $300, right?
It looks like that.
And then going into 1990, you met Erik for a double session on January 2nd, billed him $300.
Right.
You met Lyle for a double session on January 3rd, and
Oh my goodness! Oh god!
dollars on January 16th for important.
Nope.
And billed him $300.
Okay, we're going through billing
The
records
20th
here.
now.
Right, and it
Okay.
indicates that he paid you $5,500 on February 13th, 1990.
Maybe we're
Yes,
through
it
the
does.
snow.
And it indicates that on the 20th of February, you had another session with Lyle where you billed him $300.
Of course, as I say that,
Well, I don't know that I had a
Static
session
says
or I
come
didn't.
back.
It does say $300.
Or you billed him for it.
Yeah, he was billed for it.
And it doesn't indicate no-show, correct?
Well, it doesn't say anything, so
Right.
I wouldn't have any idea.
On the 27th, you billed him again $300 for a session.
Again, yes, I don't know if he was there or not.
And on March 6th, you billed him for a session for $300, correct?
And he was billed.
And the last page, which is a ledger card for Erik Menendez, you billed him for a session on February 6th, 13th, 20th and the 27th, correct?
He was billed, yes.
And you also billed him March 6, 1990.
Yes, he canceled and was billed.
And so you were seeing them according to that ledger right up to the time when the police seized the tape that you've referred to from your home pursuant to a search warrant. Is that right?
Looks to be.
And your understanding was that they were arrested shortly thereafter.
That's my understanding.
Now, returning to the October 31st session, I think you testified that one of the first things you discussed with Erik and Lyle after Lyle arrived was the limits of confidentiality. Is that right?
That's right.
And I think you said that one of the first things you talked about were the occasions where confidentiality did not apply, correct?
That's correct.
And I think you testified that you explained to them about child abuse and threats and a couple of other situations where confidentiality would not be applicable, correct?
That's correct.
And what you told them was that if either one of them threatened you, that what they told you in the session was not confidential. Is that right?
That's correct.
You also told them at the very beginning of the session, when they were both present, that you might be able to help them in the event that they were ever brought to trial. Is that correct?
Well, at some point in the context of a discussion, I told them that it might be helpful to be able to explain the family dynamics that led up to the commission of the murder, if in fact they were ever brought to trial.
And did you elaborate on that at all as to how you were going to help them or what the procedure was for helping them?
You're referring to October 31st.
Yes.
Not to the best of my recollection. In fact, I don't think I said I would help you. I think that what I said is that it may be helpful for me to be able to explain
Helpful for someone,
the
just not
family
you.
dynamics that contributed to the murder of your parents.
So, okay, let me get these. We do have a couple questions here. So Aaron Morgan says, why were the whole family seeing him in the first place? Sorry about my time. I'm struggling a little today. Yeah, no worries. No worries. So I don't know exactly why the whole family was seeing them. I think that it started with the mom, Kitty Menendez, seeing him because there was something about, there was an indication about maybe depression or something, which kind of checks out with what I've heard from other people or from the limited documentary that I did see before this trial and other people kind of giving their account, and based on what the defense has been saying about Kitty Menendez, that like she was kind of like this secondary abused person by Jose Menendez, their dad. So I think that it started with her, and then it seems like it developed into a family therapy kind of situation where everyone was kind of brought in for conversations with a therapist. I don't know if in those days confidentiality was different than it is today. I don't know particularly what confidentiality rules are for psychologists among family members. But I know that in California, as a lawyer, like you would have to get specific waivers for each individual person if you're going to, say, for example, do an estate planning document or estate planning package for a husband and a wife. You have to explain to them, like, I can't keep any secrets between you two because you both are my clients, and so I am able to, like, I can't be asked to hold a secret, but from the other person. And then there are certain ways in which it can get a little bit tricky when we're talking about, I should probably do this. It can get a little bit tricky when we're talking about then when the next generation is administering that estate planning package, if they go back to the same attorney. Sometimes you can have some tripwires that you sort of have to delicately pass through. So I hope that answers your question, Aaron. Bronwyn W says, why are they going through all the sessions? What's the purpose? I think that what they're trying to establish is that he has been in the family for a long time, and he's been kind of seeing their whole family for a long time. I'm wondering if maybe they're going to dig into, I don't know. I don't actually, no, I don't think they can ask about Kitty Menendez sessions, because that still would be confidential, for under the doctor-patient privilege. It might just be to establish that this is someone, this is not just like some guy that they just started talking to. He's someone who was very familiar with them before. Maybe the reason for that would be to show that he's like kind of like selling them downriver somewhat after having worked with them for a long time. That he just kind of like turned his back on them after they brought so much business to him. I'm not sure exactly. Sometimes these questions that get asked earlier on in a cross-examination become clearer as to why they're asking them. It becomes clearer later on down in the through the cross-examination as they get into other subjects. And you're like, okay, they were just laying a foundation for other questions that they had to ask later, or that they wanted to ask later. So yeah, I hope those answered your questions for both of you. Okay, let's continue.
But what went on to basically cause you to ultimately end up murdering your parents?
And was this explained to them in the October 31st session or the November 2nd or both?
I think it was in one form or another.
Okay. Here's an answer. Thank you so much for this. This is why I like also having some folks in the chat that have been well read on this case, is because this is background information. So Sophia Homelandel, thank you so much, says, I think Erik had to go to a psychiatrist / therapist for the robberies that Lyle did, and Erik too, the blame for because he was underage. So I think that's why Erik went to this doctor. That makes sense. So that the court ordered, because they had fallen in with a group of friends that decided to, just for the thrill of it, start breaking into their neighbors' houses and like taking random things. And so they ended up getting caught. And this is a bit of commentary on the American judicial system in the 80s and 90s, and maybe even today, depending on who you talk to, that someone, a wealthy teenager can get sent to therapy as opposed to jail. So, that's a fun little factoid. So yeah, that explains why the boys started seeing him as well.
No, they were addressed in both sessions.
Where in your notes is that reflected as to the October 31st session, if you have those in front of you?
The billing records are arguably important because they're going to lay a foundation.
It isn't present in the October 31st notes, and it's entirely possible that that I know for certain I did November 2nd, but I don't see it in the notes. Actually, might be there, but I don't see it.
But the billing records are also not as
And
spicy
is
as
it true
what we heard
that the
last week?
November 2nd notes begin with your statement, quote, I further stated that there were some ways in which the possession of my part of this information could potentially be helpful. Namely, I related to Erik and Lyle that in the event they were brought to trial for their parents' murder, that I might be able to piece together some of the events in their family constellation that led to them having the hatred and abuse, most particularly from their father, that could have led to such an event occurring.
That's correct. It does state that.
And that, in substance, is what you told them at the very beginning of the interview. Is that right?
The beginning of the interview on the 2nd?
On November 2nd.
Sometime into the interview, yes, on November 2nd.
And it's your testimony that you probably gave them the same statement on October 31st, although you don't see it reflected in the notes.
Well, I'm not sure that I gave it to them October 31st, but I'm definitely sure I gave it to them November 2nd.
Well, I think you did testify that one of the things you discussed at the very beginning of the October 31st session was the limits of confidentiality, correct?
Yes, but the limits of confidentiality is a discrete and separate issue from the issue of whether something I could say in the event they were brought to trial would be helpful if they're not connected concepts or statements.
And so the discussion about helping them in the context of any trial that might come up was maybe didn't take place until November 2nd.
I'm not sure. I know it took place November 2nd. I'm not sure about October 31st.
And is it also true that at the end of the November 2nd session, and looking at the bottom of page 18, that Lyle in particular was very concerned that you didn't get enough details down of the session?
That's absolutely true.
And is it also true that he said he wanted the notes to accurately reflect things that he thought might mitigate the severity of the crime he committed in the event he was ever caught?
Yes, he did say that.
Did he tell you he needed you as a witness?
Well, I think that as I testified, he didn't state the words. He didn't say, I need you as a witness. But basically, my interpretation from his telling me that he wanted me to get all of the detail down to mitigate whatever happened was that he needed me as a witness.
All right. And as I understand it then, he comes into the session October 31st. You tell him the limits of confidentiality. You tell him that the information might potentially be of use to him in a trial. And later on, he states to you that he wanted you to get down the details of what he was saying, correct?
That's correct.
And did he appear to understand that your suggestion that you were possibly going to be of use to him in any trial that might come up?
Did he appear to understand what that meant?
Did he appear not to be able to process that information?
No, I think he was processing that information.
Did he indicate to you that he hadn't thought of that, but something along the lines of, now that you mention it, it's a good idea?
No, not now that you mention it's a good idea. I think that he just said that he hadn't considered that the possession of notes or records of what he had said could be helpful. Didn't comment on whether it was a good idea or not.
He mentioned that he hadn't considered that your possession of the notes could be helpful.
Correct.
And then after that discussion is when you say that you had this discussion about the killings themselves, correct?
I'm not sure of the sequencing. You want to refer me back to the...
Yeah, on November 2nd, I think at some point after you had that discussion about you being of use to them in a potential trial, you then proceeded to discuss with them the killings themselves. Isn't that true?
Well, I don't know. Let me go back to the point in the notes here. Can you refer me to the page that you're...
Well, you tell me. First of all, can you testify from your own independent recollection of what was said on the date of November 2nd? Do you have any independent recollection of the
I
conversation?
have lots of independent recollections, but I don't know whether I had that particular conversation immediately after the conversation you just mentioned. I'd have to refresh my notes to see the sequencing of it. I know I had the conversation, but I don't know the exact sequencing.
So, okay, let me answer a couple questions here. Debbie Faison Cook, is he there as an expert or just because he was their therapist? He's there as a fact witness. So, although he does have a certain level of expertise as a professional in the field, he is not qualified as an expert, and he's very much a fact witness. So generally speaking, when you call a witness, they will be either a lay witness, a fact witness, or an expert witness, in which case they have to be qualified through particular steps, as we've seen in the past. So yeah, he's not an expert. And this is a similar question from Sokotoa. Is he an expert witness? No. Are there rules of when an expert witness can view their notes and when they can't? I remember Debbie heard expert witnesses were not allowed to review their notes. So a few things about this. Generally speaking, expert witnesses, they don't want them just reading their report on the stand in front of the jury, because the report is supposed to represent what the expert is going to testify to at trial. So the best evidence is going to be getting it through the witness themselves. There is always a possibility that maybe they forgot something that they wrote in their report, in which case, if they say, I can't remember exactly what I said, can I review my report to refresh my recollection, that is a proper use of a document. So this is there are some limitations to or some exceptions to certain rules of like not being able to get documents in, because remember if you watched the Gwyneth Paltrow trial, there was a moment where where the defense was like gonna try to slyly see if they could get one of the expert witnesses reports admitted as an exhibit, and the plaintiff side was like, that's categorically not possible, like blah, 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 blah. Like expert witnesses, their reports are never allowed in as exhibits. And it's what we're talking about here is the best evidence rule, because you have the person right in front of them, so why not just ask them about it? And so what Dr. Oziel just said on the stand is that he says, I independently recollect things that we talked about, but if you want a certain level of detail, I do not remember. And so I need to be able to look at my notes, if that's okay. So it's the purpose of putting those notes in front of him is not to admit them as an exhibit, but it's to refresh his recollection so that he can continue testifying. So, yeah. Okay. Let's continue.
Let me refer you to a specific conversation that you had in reference. I think you said that at one point you offered them two different scenarios of the kind of killings, and you characterize each. Do you remember that discussion?
Yes, I did.
And when did that discussion take place in reference to your telling them that you could be potentially helpful to them in a trial, and after warning them that if they threatened you, that there was no confidentiality?
That took place significantly after me warning them about the confidentiality issue.
And did that discussion also take place after what you perceived to be threats?
Did the conversation about the different kinds of murders take place?
Yes.
Yes, it definitely did.
And in fact, the threats, according to you, took place as early as October 31st, right?
They did take place October 31st and November 2nd.
And the discussion about the different types of killings took place well after both the threats and your discussion with them about the limits of confidentiality and how you could be potentially helpful to them in the event they were brought to trial.
That's correct.
And you offered them those two options, and they basically indicated that option A was the one that best fit their situation.
By option A, you mean what?
I think you testified that you offered them two options. One was a premeditated killing with no feelings, and the other was a heat of passion killing where someone does something on the spur of the moment. Do you recall that?
Yes, I do.
Loosely, that was the categorization that you offered to them?
That's correct.
And after all this discussion about possibly not being confidential, that you were there to help them develop mitigating information for their trial.
I didn't say that.
You didn't say that?
I didn't say I was there to help them develop mitigating information.
All right. Without quibbling about the words, you told them you could be potentially helpful to them in a trial, correct?
That my testimony about why things took place might be helpful, not that I was there to help them develop mitigating circumstances.
And it's also true, is it not, that they, from the very beginning on October 31st, reflected some skepticism in terms of whether what they were going to tell you was going to be confidential?
Oh, I think there was a disbelief initially that confidentiality meant anything. I think that there was on Lyle's part anyway, a complete dismissal of it.
And in fact, he was telling you what's going to prevent you from going to the police?
Yeah, he didn't believe that, as I was describing confidentiality and the limits of it, I think that he had already concluded in his own mind that there was no way to believe any of that, and that basically, that I was an unsafe person to keep around. I don't think he was believing any of the confidentiality.
I want to know why he told him that.
And yet you say that he proceeded to sign on to a version which would indicate premeditated killings, correct?
An aversion?
A version.
Oh, I'm sorry, I don't know what you mean by that. Could you tell me?
Well, let's back up. At some point after he expressed his skepticism that this was going to remain confidential, and specifically in the November 2nd session, you offered him two versions of the killings, correct?
Correct.
Option A was a premeditated killing. Option B was a heat of passion, emotional killing, right?
That's correct.
So he, according to your testimony, signed on to a version which would indicate premeditated killing, did he not?
He did.
And that was despite the fact that he had indicated some skepticism about whether that session was going to remain confidential. Isn't that true?
The primary session in which he expressed a conclusion that things were not going to remain confidential was the October 31st session. So yes, in the November 2nd session, at the point at which he was making the choice between pattern A and pattern B, yes, there had already been a discussion about the confidentiality and limits of it.
And was there any indication that you had that he had changed his mind between October 31st and November 2nd? That is, as far as you were concerned, did it still seem like he was skeptical of any claim of confidentiality that you may have been making?
I'd be speculating.
In fact, you told him that there was potential confidentiality, correct? You never told him that it was confidential.
That's correct.
To that meeting with the prosecutors and Detective Zoller, that you said you made the one tape of the October 31st, November 2nd session after the second session, and that it was within a week of the second session by the 9th of November. Remember stating that?
I don't remember it.
You don't remember stating that? Or you
No,
don't?
I don't remember stating that. I mean, I'm not saying that's not correct. I just don't remember stating it.
Well, that was a conversation that occurred just in June of 1993, correct?
Correct.
And you don't recall that conversation, but you say you do have independent recollection of a conversation that occurred 4 years ago?
Well, that's possible. I'm not saying that I didn't state that. I'm only saying I don't remember that particular statement.
You have a lapse in memory as to whether you said that, in other words.
I just can't clearly recall that I said it.
And do you also remember stating to Detective Zoller and the two prosecutors in this case on June 21st, 1993, that you had some written notes of the sessions, but you destroyed them after you made the tape?
Yeah, I don't think that's correct. I think that
The question is,
yes,
did you
yeah,
say it?
I'm sorry. Yes, I do recall having said that.
All right, fine. And so it's true, is it not, that the notes which you dictated on tape may have been made as late as November 9th?
They may have been.
Is there any reason why the 9th sticks out in your mind as to the date when you may have dictated the notes?
Just that I remember what I was doing up to, I think, the 6th. And the best of my recollection was that I made the first tapes of the first couple of sessions very near the time that I bought the two shotguns. And so since that was, best of my recollection was at the 6th.
the shotguns.
Well, what's your recollection? Do you
And then,
recall when you
Yeah.
bought the
Randomly
shotguns?
placed them
I
around his
believe
house.
it was around
Didn't
the
bother
6th,
to
November
learn
6th.
how
And
to
that's
use
about
them.
the time that I made the notes, a little bit before that or around that time.
Could have been a little bit after.
Could have been, but I remember that's basically when I made the notes. Sometime a little bit before that
Or a little bit
Little
after.
possibly could have been after,
And
more likely to be before.
but if you told the detective and the two prosecutors that it was as late as the 9th, that would be wrong. Is that your testimony now?
No, I'm not saying that would be wrong. I'm saying that that's the outside, that these events did take place 4 years ago, and I can't be 100% certain about that particular memory, about the exact day that I tape recorded those dictated notes.
And were you tape recording the notes from the journal entries that you've testified about?
No, I was not.
In other words, you were doing it completely from your own recollection, whenever date that was that you taped the notes, right?
That's correct.
And at the time you were dictating the notes, were you still in fear for your life?
Yes, I was.
Was the fear greater, lesser, about the same? How would you characterize it?
Lesser.
And is it true that between the November 2nd session and the dictation of your notes that you had no contact with the Menendez brothers until November 28th, 1989?
That appears to be correct from the ledger cards.
And if you had a greater fear, would it have been because you didn't know whether the brothers went on vacation or not?
That would be correct.
So you were dictating
Because
those.
I knew they didn't go on vacation specifically.
And so would it be fair to say that you probably were operating under a greater fear as opposed to a lesser one when you dictated those notes?
No, I don't think that would be fair to say.
It may have been a lesser fear then.
I think I had a lesser fear at that point than I had the night of the 31st, for sure.
All right. And have you listened to your voice on the tape of your notes?
I think that I listened to my voice 4 years ago. I don't recall anything about how my voice sounded on the tapes.
Do you recall whether you sounded fearful on the tapes?
I didn't recall that I sounded. I don't recall, frankly. It was 4 years ago.
And the tapes themselves don't purport to be verbatim recollections of everything that took place in those two sessions, do they?
Parts of them are verbatim and parts of them are not.
Well, how long did it take you to dictate the October 31st session?
I'd be totally guessing.
The entire two sessions are, what, about 19 pages in notes?
Approximately 19 pages of what looks to be double-spaced notes.
And the sessions themselves, I think the October 31st session was 4.5 hours.
Yes.
And it's not your testimony that those notes contain everything that was said on October 31st, is it?
No, in fact, it's been my testimony specifically. The notes don't contain everything that was said.
And that would also apply to the November 2nd, correct?
Yes, it would.
But what's in the notes are things that you chose to emphasize as important to you at the time you were dictating those notes. Isn't that true?
No, that's not.
That's not true?
No, it isn't.
All right. Did you, at some point in time, make a more complete record of the two sessions?
Not that I recall. I don't think I ever made any other record of the session than these.
Now, when Lyle came into the session on October 31st, I think he testified
So that was
he
important
was
because
both menacing.
hang on. So that was important because they just went over, well, just how accurate are these notes, right? Because you didn't take them contemporaneously. You took them, or you did your dictation sometime afterwards. And you had done other sessions with other people. You had done other sessions with them when you did these dictations. And also you didn't even include everything that you guys talked about. You kind of decided to filter in, filter out various pieces of information. So that's important about just how much the jury can potentially rely on his notes for giving an accurate depiction of what they actually talked about in these sessions. So that's important. Also, in the chat, Menendez Trials, thank you so much for pointing this out. The point of going over the session could also be to indicate Oziel had a financial motive to set up sessions and charge them whether they showed up or not. That is true because remember last week 2 weeks ago, last session, right? The last part where we were going over his cross-examination, he was going over his billing style basically for clients with cancellations, that he basically sounded like he had a very fluid policy of like with a very loosey-goosey kind of term of like, you can cancel your session with me, but unless you give me enough time to rebook the session with someone else, then I'm still going to charge you for it. So it's not a hard and fast, like you need to give me at least 24 hours, 48 hours. Like he doesn't say like 3 days, like you have to, give me that much time. He just says, a reasonable amount of time, quote unquote. And he's the one who determines how reasonable it is. And it basically is like, he basically has to be able to get somebody else to fill it in. Yeah, Mark Taylor in the chat, and enough time, right? According to his own definition. So yeah, there could be a bit of that as well. Menendez Trials, thank you so much. And also the charges increased after the confession, so the dates matter. Yes. Basically, they I think if I remember correctly, they were looking at them, but they didn't really have anything on them until the confessions happened. So yeah. Okay. Thank you for that.
And threatened. Do you recall that testimony?
Yes.
Threatened and threatening. I think you used that term. Do you recall that?
Yes.
How was he threatened? Why did you characterize him as being threatened?
No, that was totally internal, meaning that was just my assumption about how he might be feeling. He never said he was threatened.
Why did you assume that?
I assumed that because Erik told me that he was concerned that Lyle might kill him for telling me what happened and for having confessed the murder. And knowing that Lyle didn't know that Erik told me, that Lyle definitely didn't want Erik to tell me, and that he just wouldn't want me to know that Erik had confessed the murder. He didn't want anybody to know that they'd committed the murder.
Was he very upset when he first arrived?
Yes, he was.
And was it your perception he was upset at his brother because his brother had confided in you?
Yes, among other things.
And was there a discussion between Erik and Lyle at that point, at the very beginning of the session after Lyle arrived, where Lyle was basically yelling at Erik for having told you?
No, he wasn't yelling.
He never raised his voice?
No, Lyle actually doesn't yell a lot. He's
Objection.
Did he raise his voice is the question. Yes or no?
right.
Did he raise his voice? Yes or no?
His voice was raised, but he wasn't yelling.
Well, was it raised to the extent that someone out in your waiting room could hear his voice, do you think?
Not to my belief.
And was he yelling at you as opposed to yelling at Erik?
He was equally intense, I think, with both of us.
Now, this, as far as you knew, came as a complete surprise to Lyle. This meaning your disclosure to him that Erik had told you that he had confessed to the killing, correct?
That would certainly be true.
And you expected when he came there that he would have a certain amount of difficulty dealing with being surprised by that information, did you not?
Yes, I absolutely did.
That was one of the reasons why you wanted him over there, because you wanted to control the situation in terms of dealing with Lyle's emotion and handling his brother's disclosure to you, correct?
I wanted to diffuse it for Erik and myself as much as I could, yes.
And did it seem to you as time went on in that October 31st session that Lyle was being protective of Erik? Yes or no?
I'm not really sure. I mean, there were a lot of very mixed messages about that.
Well, do you remember stating in your notes that Lyle was very protective?
Somewhere in the notes, I stated that, but there also were many other statements that were contradictory to that. So sometimes people behave in contradictory ways and say contradictory things.
Yes.
That's not particularly
And
helpful to hear
so-
from someone on the stand.
He may very well have been protective.
I think he was threatening and protective simultaneously.
All right. And it's your testimony that after you had this discussion with him, that Erik left the room first, correct?
Erik left the room first.
And then Lyle went out, correct?
That's correct.
And did you at that point lock the door and keep yourself safely within your office?
No, I did not at that point.
Did you feel that you could handle the situation?
I didn't know whether I could handle the situation, but I thought I certainly had better try.
Well, you testified, I think, that you were in great fear for your life at that point. Is that correct?
That's absolutely correct.
And yet you followed both these brothers out on a dark street at what, about 10 o'clock at night?
Yes, that's about right.
Did you?
No, it wouldn't have been 10 o'clock at night. I think it would have been more like 8 something at night.
Well, what time did the session begin?
It began about 4:15 and lasted something like 4.5 hours or something like that.
So what time was it when Erik walked out and was followed by Lyle?
Might have been closer to 8:30.
And you walked out on the street. It was dark at that time?
Well, there were street lights. It was dark. Erik was parked, as Erik's Jeep was
Just how
parked
afraid were you?
some distance up the street from my office.
Did you have a weapon with you when you walked out?
No, I didn't.
Did you feel that you were in great danger by going out on the street and actually walking up to the very people that you say you were in great fear of?
I didn't think they were armed. In fact, I was almost certain they weren't armed, and I thought I would have been in great danger staying in my office and not resolving or trying to defuse the threat. So, no, I thought I was protecting myself by trying to follow them out and trying to get them to continue to talk about things to resolve the even more explosive threat that I experienced with Erik bolting from the room and Lyle following him down on the street. So I didn't perceive that I was in threat following them. I perceived I was in great threat if I didn't follow them.
So would it be fair to say that at least in terms of your own internal processing of the situation at that point, you weren't so fearful that you weren't thinking rationally?
I'm sorry?
Would it be fair to say that based on your own internal processing of the situation, that you weren't in such great fear that you were acting completely irrationally at that point?
I don't think I should be characterizing my degree of rationality. I think I would say that those are the actions that I took, and I was definitely feeling fearful.
And so you approached them at their Jeep outside, correct?
That's correct.
Didn't know whether they had a weapon in the Jeep.
Believe they didn't.
Walked right up to the Jeep and tried to urge both of them to come back in with you. Is that right?
That's correct.
And it was at that point, according to your testimony, that Lyle shook your hand and said, "Good luck, Dr. Oziel," or words to that effect, correct?
Among other things that he said, yes.
Are you sure that conversation where he shook your hand and said, "Good luck, Dr. Oziel," didn't happen up in your waiting room?
Yes, I'm absolutely certain.
Are you sure that it didn't happen at the elevator before you went down
100% positive.
in the presence of Judalon Smith?
No way.
You have no recollection of her being outside in your waiting room when you came out following Lyle, correct?
Do not have any.
And she could not possibly have seen you talking with Lyle Menendez at the entrance to your elevator, correct?
I don't believe so.
At some point during right after they left, I think you said that you called a number of people, correct, immediately after?
That's correct.
And when you were making those phone calls, you were in your office, correct?
That's correct.
Was Judalon Smith sitting on the desk watching you make these phone calls?
No, not to my recollection.
Was she rubbing the back of your neck trying to soothe you as you made these phone calls?
No, she wasn't.
Are you positive of that, or you just don't recall?
No, I'm positive she wasn't sitting on my desk rubbing my neck.
And I think you testified that one of the people you called was Bradley Brunon, correct?
I believe so.
And you testified that you dialed Bradley Brunon from area code 310-278-6342.
Well,
To the best of my recollection, I think I
changed their number
testified
after
that I
that.
didn't recall when I called Bradley Brunon, whether it was that night or whether it was the next day or whatever. It was pretty soon after these events, but I can't state certainly when I called Bradley Brunon.
Well, do you remember at page 9496 of the daily transcripts? August 4th. And actually beginning at the bottom of page 9495, your statement, "I don't believe Judalon Smith was in my office. I don't recall having seen her." Question, do you know if she was there? I can know if she walked into the waiting room. No. Question, did she walk into your office, into your field division when you were making the phone calls? Answer, no. Question, who did you call? Answer, I called several attorneys. Question, who? Answer, I don't remember all the names of the attorneys that I called. Question, who do you remember? Answer, one of the people that I called was Mr. Brunon. Question, and you called him from your office phone? Answer, yes, I did. Question, and what was the number of that phone? Answer, what was the number of Mr. Brunon's phone? Question, yours. Answer, my phone, 310-278-6342. Do you remember that testimony?
Yes.
Your Honor, there's three more exchanges that should be read at this point to put it in context.
All right.
All right, yeah. Mr. Brittle, continue.
Question 278-6342. Answer, that's correct. Question, and did you reach Mr. Brunon? Answer, I don't recall. I actually talked to a number of people over several days, and I don't know who I called or didn't call. you remember giving that testimony?
Yes, I do.
All right. So is it true that you called from area code 310-278-6342 on the night of October 31st, right after these alleged threats were made?
Objection, this case is the testimony.
I did call people from that phone number. Absolutely, I did.
And one of the people you called was your wife,
I definitely called my wife.
and your wife was at home when you called her, correct?
Yes, she was.
She was in the 818 area code, correct?
Yes, she was.
And have you taken a look at your phone records to see if that's corroborated?
No, I haven't.
Next, we're going to
Exhibit 111.
Can I put you in, Sean?
Yes.
Showing you exhibit number 111. Do you recognize this document as your November 4th, 1989 phone bill from your office, Doctor?
It looks to be.
All right. And if I could just direct you to the last couple.
He's doing a decent cross-examination, but it's just
In
not quite
yellow
the same as
beginning
watching Leslie
on the first
Abramson.
page
Whether
of
you
this
love her
bill.
or you hate her, she
You'll
is
see
entertaining.
For dates other than October 24th, there are calls to the 818 area code. You see that, for instance, October 24th. There's a call to 818-335-2029.
Yes.
All right. Let's take a look at October 31st. On the first page of this exhibit, there are three calls highlighted in yellow on the 31st, correct?
Correct.
You made a call at 9:58 a.m., or somebody did from your office, to somewhere in California in the 818 area code
Appears to be.
at 9:58 a.m., correct?
Someone did.
So that would have been before this session took place, right?
Right.
And the second two calls highlighted here is a call made at 3:26 p.m. and another at 3:36 p.m., correct?
That's correct.
Those were all made before this session.
Right.
And you'll see on page 4 of the records, again, highlighted your October 31st billing. There's a call made at 9:57 a.m., one made at 10:34 a.m., and one made at 3:01 p.m., correct?
Correct.
Those are the only calls made on the 31st on that page.
Those are the only calls that are toll calls on that page.
Right.
Right.
And on page 5, there are 9 calls made, correct?
Appears to be.
And there's a call made at, all the calls predate 4 o'clock when the session began, correct?
Correct.
With the exception of a call which was made at 4:35 p.m. to Plainsboro, New Jersey.
Right.
Did you make that call?
Certainly did not.
How about the call at 4:42 p.m. to Princeton, New Jersey?
Nope.
Another call at 4:42 p.m. to Plainsboro. Did you make that call?
Nope.
How about the call to 6:32 p.m. to New York?
No. I don't believe so. I don't recall any of those numbers.
All right. I think you said yesterday that you, or a couple of days ago, that one of the phone calls you made was to a police department outside the Los Angeles area.
Well, outside the Los Angeles area, I mean, it could have been Culver City, or it could have been Pasadena. It wasn't somewhere in the middle of the state. It was just some small separate police department somewhere around, and I don't recall which small city it was. Could have been anything.
And do you see any of the calls there on the 31st that could reflect any police departments or attorneys that you called?
I think that the answer is that I don't know that any of the calls that I made would have been toll calls. I don't know why you're assuming they would be toll calls.
Well, do you see calls to the 818 area code on there? Yes.
Yes, but the 818 area code, my home, calling from my office to my home was not a toll call. To the best of my recollection, absolutely not.
You see no 818 area code?
I see no 818. My phone numbers on this whole bill, and I call my home probably 10 times a day. So I absolutely believe that it was not a tow call to my home.
What's he doing calling his home 10 times a day?
That phone?
Yes.
You're positive that you made it from that number?
That's the best of my recollection. I mean, I have a memory of it.
And are there any toll calls on there outside
Yeah, Mark,
your area
this is another
that you recognize as
bit
having
of
been
technology
associated
that
with
has
your calls
definitely
to
moved
people,
on.
such as attorneys or police chiefs or anybody else?
You're referring to October 31st.
October 31st.
I see no toll calls that indicate that I made calls out of area, and I had a wide area that was covered within my phone bill that was not a toll call. I see no toll calls, but these are not calls, they're toll calls.
And do you have any record that you made the calls?
No, I didn't keep a record of making the calls.
Now, I think you said that when you called your wife that night, you told her, one of the things you told her was that you were going to have to go stay with Miss Smith that night. Is that right?
That's correct.
Did you tell your wife that the reason for that was because you had a confidential relationship with Miss Smith?
No, I didn't.
What did you tell her?
I believe that I just told her that I needed to stay with Miss Smith, and I probably shouldn't be anywhere near her that night because my belief was that that Erik particularly knew where I lived, and I thought that the most dangerous place for me to be going that night was to my own home.
And did you tell your wife why you needed to go to Miss Smith?
I think I just testified that that's about the totality of I recall having said to my wife.
Did you need a reason to go to Miss Smith? In other words, were you free to spend the night there without this explanation that there was a threat?
No, I think that once my wife heard about the threat, I don't think she was particularly concerned about me spending the night at Miss Smith's house. I think that she was focused on the threat, not that.
No, but my question is, did you need a reason in order to stay at Miss Smith's house? In other words, were you free to stay overnight at your girlfriend's house, or did you need some specific reason in order for you to spend the night there?
I don't know how to answer that except to say that I didn't just spend nights at Miss Smith's house and not go home. So yes, I needed a reason.
All right. And in this case, the reason.
Weird. So weird. So apparently the wife, sounds like she definitely knew about Judalon Smith. And like, this was just like a living arrangement that she was just sort of like, I guess on some level okay with, even if we have no idea whether she liked it or approved of it or was unbothered by it. I would imagine she would be somewhat bothered by it, but that's just so weird. That's weird. This whole that whole exchange just now was just so weird.
Reason that you gave to Miss Smith was that she was potentially threatened, correct?
No, I wouldn't say that at all.
Well, what reason did you give Miss Smith as to why you needed to come over to spend the night with her?
Oh, yes. I told her that I had been, that I perceived that there was a danger and I needed to have some place to stay.
And she told you to come on over, correct?
Best of my recollection.
And then that night, you went over and spent the night with her, and where'd you go the next day, which would have been the 1st, November 1st?
I don't recall. I think I just stayed. I think I stayed with Miss Smith pretty much through the week and through the weekend, trying to stay away from my home and being anywhere where I could be easily located.
And that weekend, I think you testified you took Miss Smith to a weekend in Newport Beach, correct?
Yeah, we left town to avoid being found by going to Newport Beach. That's correct.
Was that a weekend that you had planned prior to this these two sessions?
No.
And how did you explain that one to your wife? What did you say to her as to why you needed to go to Newport Beach with Miss Smith?
I said, I think that you better be out of town, which they did go out of town, and I better be out of town because I think that these people are not going on vacation, and I feel very threatened by that. So you need to not be anywhere where you could be located, and I need to be someplace where I won't be located, and so does Smith.
And did you indicate or explain to your wife why it was that you needed to go to Newport Beach with Miss Smith as opposed to going wherever it was that you sent your wife?
Yes.
What did you explain to her in that regard?
That I wanted to make absolutely certain that I didn't expose my wife or my children to being with me, which would make me much more identifiable as a unit. Didn't want to be checking in under my name. Wanted to have her be a totally separate place to make sure that there wasn't any possibility that I could be followed with her going on vacation. I didn't want to be followed with her.
And is it true then that you were less concerned about Miss Smith's safety?
No.
That is, you were willing to take that chance with her?
That's what it sounds
No,
like.
I think it's would be much more accurately stated that I thought that it was dramatically less likely that they would have any idea where Miss Smith lived to be following me from Miss Smith's house. It wasn't impossible, but it's much less likely. And I thought if I went to my own home, picked up my kids and family, and then went on vacation with them, I thought that would be a much easier way to find where I was. And I also thought that Miss Smith might need some protection by being with me, since I had already warned her that I thought she was in danger. So the
But then
best solution
does
in
that put
my
her in
mind at
more
that
danger by
time
being with
was
you?
for me to be protecting Miss Smith by taking her out of town, and for me to be protecting my family by having them go to a different location.
All right. And did you keep them in?
I feel like there's so many levels of bullshit in that answer, because he's like, no, like I feel like Judalon Smith was more protected by me being around, but that's not the case for my wife, because like that's not protecting her for me to be around her, but it is protective for me to be around the girlfriend. No, I don't buy it. It feels like a whole lot of bullshit that he just has very smooth delivery. And so he thinks that it's landing. I don't think it's landing. Aaron Morgan says, I thought he went back to the office and saw patients the week later, right? Yes. He also went right back to work and was seeing patients at the office. So if he was so terrified of them finding him, why wouldn't he be terrified of going back to work, which was literally the place that he saw them? Like that is literally the place that he spent time with them, was at the office. So it's just this guy is just ridiculous. His logic just does not make sense to me.
In that basic constellation for a long period of time?
I don't know about a long period of time. I think past the weekend or through the weekend.
Well, did the threat automatically disappear at the end of the weekend when you came home from your weekend?
No, it didn't automatically disappear.
How did you decide to come back from your weekend at Newport Beach with Miss Smith in relation to the threat?
I just think that I talked a lot of the weekend, talked things through. And I think that when I came back, I felt that I couldn't stay forever on vacation. So that wasn't a permanent solution to dealing with the problem.
You couldn't stay forever on vacation.
Couldn't stay away. Couldn't stay out of town.
Well, you said vacation.
I said it.
Was this a vacation for you?
No, I'm amending that.
All right. And when you came back from the weekend, vacation, whatever, where did you take up residence?
I believe it was my own home. Can't recall specifically which day I returned to my own home.
Well, was there some reason why you thought the home was not a safe place to be after your vacation?
Didn't think the home was a safe place. Took a lot of measures to increase my security, to protect myself at my home.
Well, you didn't buy the shotguns till the 6th, right?
That's correct.
When did you get back from Newport Beach?
I don't recall the date. I guess you have to sort of work backwards. I don't have a calendar. If you gave me a calendar, I could. How about if I open this one?
Sure.
Okay.
Shireen, it does sound like excuses to be with his girlfriend. It just sounds like that's the one that he preferred to be with. So he went with her. Yikes.
Okay. It appears that I would have gotten back from a moment here. From Newport Beach, approximately the 6th.
Which was what day?
A Monday. I don't know if I'm looking at the right year. I think I'm looking at 89. Is that correct? Yeah, 89.
Yeah, it should be November 89.
November 6th.
So you were down there from Friday night until Monday?
I believe so.
But were you able to have any enjoyment at all down there on this weekend?
I don't believe I had very much enjoyment at all that weekend.
Well, were you able to go out of your room, or did you feel so fearful you had to lock yourself in a hotel room?
No, I believe that we went out of our room.
Where'd you go?
I don't recall, just to dinner, I think.
Did you lay out at the pool at all?
I don't recall having been out of the pool.
Go to the beach?
I don't recall having been to the beach.
And when you came back, you went directly to your house, or where'd you go when you came back?
I don't recall. All I recall is that that ultimately after that weekend, that I did go back to my home.
And did you instruct your wife that after this weekend with Miss Smith, she could now come back to your home, that it was safe?
I never said anything about it being safe. I only said I thought we needed to take a lot of security measures.
Well, did you tell her she could come back to the house?
I told her I thought I couldn't stay away permanently, and neither could she, and we had to figure out a way to be secure within the house.
And so did you tell her, let's meet back in town and we'll go and buy some shotguns and then move back into the house?
No, I don't think that it happened that way at all.
Well, how did it happen?
I don't recall. After I was back in the house, we had some discussion about increasing our security, and one of many measures that we took was to buy the shotguns.
Well, the many measures, the only other measure you took was to have your security system updated, correct?
That's incorrect.
You had your security system updated on November 16th, correct?
I don't
when
remember the dates.
If a security person testified, that's when they came out and reactivated your system. Would that be inaccurate testimony?
I don't know. I don't recall.
Did you feel that the threat continued between November 6th and November 16th?
Yes, I did.
When did the threat go away?
Never did.
Never did, up to the time when the brothers were arrested, correct?
Never did.
And did you receive these shotguns on the 6th?
Best of my recollection.
And when was it decided that you'd be better off moving Miss Smith into your house?
I didn't decide that I'd be better off moving Miss Smith into my house.
Well, at some point she ended up living in your house, correct?
Yes, she did.
Was that related to her fear or yours or some other reason?
No, that was related to her fear.
And what did you explain to your wife as to why your girlfriend was going to move into the house with you?
I explained to her that that Miss Smith had said that she was terrified now to be left alone in her place with my going back to live with my wife and family after all this was over with, and that she felt very insecure and very frightened and didn't feel that she could feel safe or secure alone, and that she felt in a complete bind. And she asked me if out of her fear that something would happen to her, she felt sort of abandoned, if you will, and asked me if she could come and stay at our house for a while until she got to the place where she felt less threatened. And so I told my wife that that was a situation, that she was afraid to live alone, and that under the circumstances, I thought that for a little while, it might be okay to have her stay there until her own fear level abated.
Well, how long did she stay in your house?
It was several months, but I don't recall the exact amount of time.
Oh
Roughly.
my God. I can't imagine that went over
it was
well.
sometime between, sometime in December through, I think, the first part of March.
I think he testified back on
Everybody
August 5th,
lived
and
all
one of
in-
the reasons
all under
why
one roof.
you felt it necessary to involve Miss Smith in this, although you characterized her as unstable, was that she had continued
Right,
to
he did say
assert
she was
herself in
unstable.
terms of trying to stay in the relationship. Do you remember that testimony?
Yeah, but I don't know that I said that that was the reason that I had her come and stay in the house. I think that it certainly was true.
No,
She
you
kept-
misunderstand me. I said
Yes.
one of the reasons why you said that you initially involved her in this situation was because she had continued to assert herself in terms of trying to stay in the relationship.
Well, it went beyond that, but yes, she did. She did continue to try to assert herself in the relationship, but it went dramatically beyond that.
And when you say it went dramatically beyond that, you mean to say that she was basically pursuing you in a way that you didn't think was appropriate.
I would go beyond that.
What do
What did
you
you
mean by that?
characterize how far beyond that you'd go?
Well, each time that I told her that I didn't want to be in the relationship, she would threaten to commit suicide,
Oh, geez.
and in fact,
That's not
one
good.
point did. threatened to did in fact attempt to commit suicide. And so at the time that this all took place, October 31st, within 2 weeks before that, as I told her that I was going to wrap up things and not be able to see her anymore, she had written a suicide note and basically stated that she wasn't going to live anymore if I wasn't going to let her continue to see me in some way.
By the way, Miss Smith was not only your girlfriend, she was your patient, was she not?
Absolutely not.
That's not true?
No, it's not true.
Did you ever diagnose her?
No, I did not.
Did you ever consult with her over the phone?
No, I did not in a professional way.
Well, what do you mean by that?
I talked with her over phone conversation, same kind of conversation that I'd have with a friend.
Did you do telephone consultations where you would diagnose her?
No, I didn't.
So that 112.
You're asking for an exhibit to be marked, is that right?
Next in order would be exhibit 112. It's
Long
half
day.
a page letter dated September 3rd, 1989.
Maybe a question.
Yes, we'll take our recess, and at this point, it's 1:45. We'll resume at 1:30, ladies and gentlemen. Don't discuss this case with anyone.
Don't form any
Don't
opinions.
be in a position where others discuss it in your presence, and don't form any final opinions about it. And we'll resume at 1:30. Both juries return to their respective jury rooms. All people in the audience, please stay put until the jurors leave. All right,
Oh, my
the
goodness.
jurors have left the courtroom. Just a few remarks before we deal with the exhibit. Remark has to do with the conduct of counsel during the questioning of the witness, specifically that of Miss Abramson and mugging to the audience during the testimony of the witness. Was there some reason for that?
I don't agree that I did that.
What were you doing when you looked towards the audience, smiled, and got a reaction from a lady in the audience?
Was looking at a family member.
And her reaction to you was what?
She was smiling at me when I turned around. She was still smiling.
And you're saying you weren't smiling or mugging at her, rolling your eyes, or anything of that nature?
I was smiling at her. She's the defendant's aunt.
Why were you smiling at her during the witness's testimony?
Uh-oh.
Because I know what they think of what the witness is saying, and I was offering support.
And if the prosecution would do the same during your client's testimony, how would you react to that?
As long as it wasn't in front of the jury, it wouldn't matter to me.
Well, counsel, the jury is right behind you and to your left.
The way I looked at it.
You don't think they can look back and see you? I could see your eyes rolling when you're facing the witness.
The jury can't see that either.
There's a jury in the jury box who could easily see what you're doing.
All right. I will try.
Is there some, no, not try, you will succeed in not mugging for the jury, not making
He is
faces to
not
the
happy
audience.
with
You will
her.
behave professionally. Is that clear?
Yes, of course.
Right, and
Yeah.
if it happens
She got in
again, I'm
trouble.
not going to deal with it in this fashion.
Right.
And the lady in the audience, what is your name?
My name's sir?
Yes,
Marta
You're-
Menendez County.
okay.
The lady I was looking at.
I
She's a family
don't
member.
recall, don't know who you were looking at, but she reacted as well as the young lady in front. I don't know who she is.
I wasn't looking at her.
All right, ma'am, if you want to remain in this courtroom during these proceedings, you are not to react at all to what goes on during these proceedings. Do you understand that? And if you can't follow that simple instruction, you will not be permitted to remain in the courtroom. Do you understand?
Oh, boy.
All right, the young lady in front, what is your name?
Summer Lafreniere.
What?
Summer Lafreniere,
And are you related to anybody involved in this case?
related to one of the attorneys,
Which one?
Jill
It's my
Lansing.
niece.
Okay, again, if you want to be in this courtroom during these proceedings, you're instructed not to react in any way to what goes on. Do you understand that?
Yes, sir.
Right, and that applies to everybody in the audience during the entire process of this trial.
Your Honor, I don't know if the court's aware, Ms. Cano is going to be a witness for the defense. We have allowed her to stay because in fact she's a family member. And we have not made a motion to exclude, even though we're aware of her presence and aware of the fact that she's on the witness list. But we can't monitor, we can't conduct the trial by looking in the audience the whole time. So perhaps at this time it would be prudent to have her excluded until she testifies. I believe it will be this week. I think she's going to be testifying within the first few witnesses.
Is that correct? Is she going to be a witness call this week?
Yes, she is.
And is there some reason why she should remain in the courtroom rather than be excluded until she testifies?
It's just that it hasn't been the policy to exclude family members until they testify.
All right, I will permit her to stay, but if I see any reaction whatsoever from her at all, or if I hear of any, then she will be excluded.
Oh no.
And I don't take this entire matter lightly like counsel might. This is a very serious part of the trial, and if counsel feel that they can make editorial comment during the testimony of the witnesses by reacting to it, they're very much mistaken, and the court would take very strong corrective actions if it recurs. All right,
Yeah.
there was some objection regarding the exhibit, is that right?
Yes, Your Honor, I asked Mr. Burt to give Exhibit 112 to the court so
So-
the court could review it.
And just to make that point, so I mean that was such a minor thing for her to turn and sort of like smile at this other witness / family member, and for the other one, and for that same smile to be returned. Judges can be very, very, very tough on any kind of reactions by the attorneys, by other people in the gallery. Some judges are a little bit more lax on enforcing it, but some judges are super tough. And based on the way that this exchange just went down, I would not be surprised if the judge here said found one more reaction out of that person and was like, "You're gone, get out of here." And it's not a big one, right? So this was a yeah. I don't know, and I don't know if this is because of bias. I think I definitely get an impression that Judge Weisberg does not like Leslie Abrams. But as for that's rules of conduct in the courtroom. It may have just been a convenient thing that he saw her making that reaction, but it could very well be that that's the kind of reason why he doesn't like Leslie Abrams, is because she does that kind of stuff in the courtroom. I don't know, but anyway, yeah, that's Abrams kind of got caught in 4K there, and well, I guess it's more like 480p from the 90s, right? But she had to basically quickly fess up and be like, yeah, I mean, I smiled at her because something. I knew exactly what she was thinking during the testimony. So, yeah. Okay. Let's, we're going to skip through this, objections over the exhibit, and I'll try to find the spot where the jury comes back in.
Review it.
Okay. Discussion. Are we back now with the witness?
Bert, so you may resume your.
Okay.
Thank you. Sir,
and
just to
Abrams have a
refresh your
history?
recollection, right before we broke for
I don't know
lunch,
about
you
that,
testified
Karen Morgan.
under oath as follows. Question. By the way, Ms. Smith was not only your girlfriend, she was
And I'm sorry, I'm totally interrupting this question. Deputy Faison Cook, why is she allowed to remain in the courtroom if she's going to be a witness? Because they didn't invoke the rule in this trial. There was at least one more witness that there was a question during one of the recesses as to whether they were going to ask, or whether the judge was going to admonish a witness in between, like during a lunch or something like that, to not talk to attorneys, not talk to anyone, et cetera, et cetera. And he was like, no, like this is the prosecution's witness. You can talk to the prosecutors. Like, that's fine. And so I think that some of the witnesses in this case also are allowed to be in the courtroom if they are family members, and then others are not if they're just like normal witnesses. So it is a little bit of a weird quirk, right? Right. Okay, let's continue.
she was your patient. Was she not? Answer, absolutely not. Question, that's not true. Answer, no, it's not true. Question, did you ever diagnose her? Answer, no, I did not. Question, did you ever consult with her over the phone? Answer, no, I did not in a professional way. Question, well, what do you mean by that? Answer, I talked with her over the phone conversations, the same kind of conversation I'd have with a friend. Question, did you do telephone consultations where you would diagnose her? Answer, no, I didn't. Do you recall giving that testimony?
Yes, I do.
Right. And showing you exhibit, what has been marked as exhibit number 112. May I approach a witness? Yes. Thank you. Just a minute to read that to yourself.
Okay, I read it.
Okay. Is that a typed letter dated September 3rd, 1989?
Yes, it is.
Is it addressed to whom it may concern?
Yes, it is.
Is it signed by J. Jerome Oziel, PhD, MFCC, Director, Beverly Psychiatric and Psychological Center, Associate Clinical Professor of Psychiatry, School of Medicine, University of Southern California?
Appears to be.
Is that your signature on the letter?
Looks like it.
Would you read to the jury what it says after to whom it may concern?
Yes. It says Judalon Smith was incapacitated 8/30/89 by a chronic stress-induced panic disorder as reported to me by her via telephone. This panic disorder manifests itself in this individual by periodic lateral anesthesia and paresthesias, numbness and tingling that render her seriously incapacitated in related to motor function. In particular, this condition would render her incapable of operating a motor vehicle and possibly of normal ambulation. Based on extensive phone consultation, I advised Ms. Smith not to attempt to leave her domicile and or drive until these symptoms were ameliorated or eliminated. This advice was predicated upon the conclusion that ambulation and or operation of a motor vehicle during this period could endanger Ms. Smith and or others.
And it's signed by you, correct?
Appears to be.
Sounds like he's
Well, do you have
diagnosing
any doubt
her.
about that?
I don't remember the letter. So the signature looks like it's mine, but I don't recall the letter.
You think it might be a forgery?
Didn't say that. I said I don't recall the letter.
I'm asking you, you recognize your own signature, do you not?
It appears to be my signature.
Uh-oh,
take a
that's
look
an
at it.
impeachment.
I did take a look at it.
And do you know your own signature?
Roughly, that looks like it resembles my signature.
Well, when you say resembles, is there a doubt in your mind based on you're writing your own signature, whether that's your signature on that letter?
It looks like my signature. I don't recall the letter.
The question is that your signature based on your, let me back up. Do you know what your own signature looks like?
Objection, ask me, answer.
No.
Yes, this appears to be my signature.
And my question is, do you have some doubt about that?
No, I said it appears to be my
Are
signature.
you trying to convey to the juries that it may have been forged or it's not your signature?
I only said that I don't recall
Good
the letter.
questioning.
Looks like my signature.
This is really good cross-examination right here, by the way, where he's just like nailing him into like this idea that he wrote this letter. He absolutely wrote this letter because just a couple minutes ago, he said, he's like, no, I've never diagnosed her. I've never treated her. I've never, I was just sleeping with her. She was just my girlfriend. I didn't, pass through any sort of professional barriers into this relationship to like mix my love life with my work life. No, I didn't do any of that. She was just like, we just had like some business stuff on the side that we were kind of maybe doing. And so, he says that with a straight face. And then boom, this letter, which by the way, it's risky sometimes it's risky to give him the letter to read it, but it is effective if he actually does read it and he reads it through smoothly. But he did. He read the letter smoothly. It was like, to whom it may concern, all this about Judalon Smith and her mental situation and how she's like incapacitated and like completely diagnosing her, basically like a doctor's note from him in his signature. And so, he's trying to wiggle out and say like, I don't recall this letter. I don't recall this letter. But he's like, the attorney here is saying, let's focus on your signature. Is this your signature? Did you sign this? Do you recognize this? This looks like your signature. Are you trying to convey And he's trying to sort of like waffle a little bit, like soften the edges a little bit and say like, I mean, it looks like my signature. And so he's hammering even more in this cross-examination by saying, are you trying to convey at all to this jury that there is a possibility that someone else wrote this signature, that someone else forged this on your behalf? And so, and he's just boxing him in little by little with these questions. It's a really, really effective way of cross-examining someone who doesn't want to testify to something because it's very damaging, because it's the exact opposite of what he just said. So this is really, really good.
And in the second paragraph of that letter, which you read rather quickly, it begins with a sentence, based on an extensive phone consultation, I advise Miss Smith not to attempt to leave her domicile and or drive until these symptoms were ameliorated or eliminated.
Oh.
Do you see that sentence?
Yes, I do.
When was he
Oh my God. And this is great. This is great. This is beautiful right here, because like I said, at first he had him read it, and now he's like, okay, let's go through it, because you read it kind of quickly. So let's go through this portion right here. I want to focus in on this part right here where he, he's like, based on an extensive phone consultation. And this is what I say is going on with this woman. I mean, everything about this letter just screams, I am a doctor who is diagnosing this woman and writing a doctor's note on her behalf, which is just like, he's really just taking this apart like thread by thread to show the jury that Dr. Oziel is shady as shit. Okay.
extensive phone consultation that you conducted in reference to this letter?
Well, specifically, Ms. Smith called me and told me that she was having these symptoms, and she asked me to do her a favor. I'm assuming that that's what this letter relates to. And the favor had to do with her having a small claims court hearing where she felt that she wasn't feeling good and was having panic attack symptoms and so on and so forth, and said she was going to lose her case if in fact she didn't get some sort of an excuse or letter or something stating that she was in fact having anxiety attacks, so on and so forth. So she.
Oh my God. So not only does he remember this letter, so he, that's another lie right here that he just caught himself in. Yes, he remembers the letter. He remembers why he wrote it, and it was to get her out of court. Good Lord.
She asked me to write a letter that she could use in small claims court that had to do with simply relating what she told me over the phone, putting it in writing so she could use it to try to get a small claims court extension so she wouldn't lose several $1,000s in rent she was due or something of that nature. And as a favor to her in the capacity of the relationship we did have.
So it was a dispute with her landlord. It was a dispute with her landlord that she was in. She hadn't paid her rent. And instead of being someone in her life to say, you've got to get yourself back up to speed. You've got to pull yourself up by your bootstraps. He's like, yeah, I'll help you get out of court. I'll help you get out of court. That's fine. That's cool.
Have, which was friend, business person, a girlfriend, however you want to characterize it. Apparently, I wrote a letter as a result of a favor that she asked me to do, in the same way that maybe a next door neighbor would ask the doctor who lives next to him. My kid was out of school yesterday with a cold. Would you mind writing a letter for the school saying that my kid was out yesterday? And it was in the capacity of the exact relationship that I've described with Smith that I wrote this letter as a favor to her and upon her request.
So when you told the jury just before the lunch break, in answer to the question, did you do telephone consultations where you would diagnose her, and you gave your answer, no, I didn't. That was false testimony.
No, to the best of my knowledge and belief, it wasn't false testimony. First of all, there is no psychiatric diagnosis here, according to DSM-3 or period. There's a list of symptoms that she reported to me, and I think I said reported to me by telephone. And this was not a professional consultation. She was asking me to do her a favor in the context of a friend-girlfriend relationship.
When you testified under oath to this jury
That
before the
doesn't
lunch
sound
hour
good.
in answer to the question, did you ever diagnose her? And your answer, no, I did not. That was false testimony, was it not?
If this is construed as a diagnosis, that would have been false testimony. If it's not construed as a diagnosis, it wouldn't be.
And the first sentence of that letter says, Judalon Smith was incapacitated 8/30/89 by a chronic stress-induced panic disorder, as reported to me by her via telephone. Is that a diagnosis?
She reported to me that that's what she had. If it was a diagnosis by me upon examination of her, I guess it would be, but it wasn't.
And you just testified, I think, that your understanding was that she was going to use this letter as part of a court case. Isn't that true?
As part of a small claims court case to explain why she hadn't been able to get in time for her to continue her case to get her money back from somebody who owed her some money.
So you knew that this letter was going to have some use in the court proceedings that she was involved in. Isn't that true?
Believe that that's how she was intending to use it.
And you wrote the letter in such a way to make the court or whoever was considering the letter think that you were diagnosing her. Isn't that true?
I wouldn't know what the court would think, but I wrote it to give her a reason, basically, based upon what she reported to me, why she was in fact not able to get to court so that she wouldn't needlessly lose several $1,000s as a favor to her.
Well, you signed it J.L. Jerome Oziel, Ph.D., MFCC, Director, Beverly Psychiatric and Psychological Center, Associate Clinical Professor of Psychiatry, School of Medicine, University of Southern California, didn't you?
I did.
And you also tried to create the impression with whoever was reading this letter that your diagnosis was based on an extensive phone consultation.
Yep.
Isn't that true?
I'd say that would be a reasonable assumption.
And did you think when you wrote this letter on September 3rd, 1989, that it was false? That is the information in here as reported to you by Ms. Smith and as you diagnosed her, is that false information you were trying to provide to the court?
First of all, I didn't diagnose her. She stated to me that she had these symptoms, and I simply
He's stalling.
reiterated what she
Why is
told
he
me she
stalling? Just
had
answer the
and simply
question.
signed it. And it was in the context of a long-standing personal and business relationship.
Question, doctor, is did you think the information in this letter was false when you wrote it?
No.
Were you
So, and that's good. Again, good cross-examination. Like, he's not as flashy as Leslie Abramson, but he's really good because he asked a question asking, did you give false information to the court through this letter? And then he's like, well, first of all, blah, 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 it wasn't a diagnosis, blah, 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 blah. And then like, that's the end of his answer. And then the attorney just comes back in and says, the question was, did you falsify information to the court to the best of your knowledge? And then finally he answers no. But do you believe that? I don't know, man. I don't know.
Were you trying to create the impression for the court or whoever it was she was going to use this letter for, that you were the doctor and that this was your diagnosis? That is, that she suffered from chronic stress-induced panic disorder.
I think I was trying to create the impression that she couldn't come to the court in time for her to save her a couple $1,000s because that's what she actually was telling me on the phone and asking me to write the letter.
Well, you didn't sign this letter, L. Jerome Oziel, concerned citizen.
I don't think that's what it says, no.
You didn't sign it, L. Jerome Oziel, boyfriend, did you?
No, it doesn't say that either.
You signed it in your official capacity as a psychotherapist, did you not?
I did sign it that way.
And I asked you again, sir, whether or not Miss Smith was your patient as well as your girlfriend around September 3rd, 1989.
She was not.
Did you believe on September 3rd,
Doesn't matter what his answer is.
1989 that she was suffering from chronic stress-induced panic disorder?
That's what she told me.
Did you believe, based on what she told you or otherwise, that she was suffering from chronic stress-induced panic disorder when you wrote this letter on September 3rd, 1989?
That's what she described. I didn't not believe it.
But you wrote in a letter signed by you that that was your diagnosis.
I was just reporting. No, I was reporting what she told me.
Okay. And you were putting your doctor's signature on that.
Doctor, do you have a term in psychology for someone who makes statements about somebody else but is really saying more about themselves than they are about the person they're describing?
No, I don't know of any phrase that describes that.
You've never heard of a phrase that describes someone who makes a statement about somebody that is more descriptive of the person making the phrase than it is the person being described?
No, I'm not aware of any such phrase.
Okay. And do you know what the term projection means?
Yes,
What is projection?
I'll let you define it.
Well, you tell me. It's a
Well,
psychological term, is
You're
it
the
not?
This has
Doctor.
to do with basically imposing upon other people things that you're actually feeling.
Isn't it the tendency to ascribe to another person feelings and thoughts or attitudes present in oneself? Is that a good working definition of it?
That would be a definition.
All right. And do you remember at some point in time that you called a press conference to make certain statements about Lulow Smith?
Yes, that's true.
Were you under a court order to hold that press conference?
No, I wasn't.
Because you testified here on direct examination, you were under court order, but you weren't under court order to hold a press conference, were you?
No, I certainly was under court order to appear in this court. In fact, I was an involuntary witness.
Right. But no one ordered you to hold press conferences, did they? I mean, ordered by a court.
I believe I testified, no, there was not a court order to hold a press conference.
And you held the press conference on September 13th, 1990.
I don't recall the date.
Would
Who
it
is this,
refresh
Mary
your
Sanderson?
recollection if I showed you the written documents that you and your lawyers handed out for that press conference?
If you'd like.
Number 13 is a set of phone records. 113, excuse me.
All right, 113 are phone records, is that
Phone
right?
records for the number 818-906-8853. Exhibit number 114 is another set of phone records for area code 818-917-5083. And exhibit number 115 is a packet of documents entitled Media Alert.
All right, 113, 114, 115.
Again, may I approach a witness?
Yes.
Thank you.
Is this like a transcript of the press conference or something?
And the letter, I'm not sure if I stated this for the record, is 112.
Yes, we've already marked that 112.
Dr. Oziel, showing you this packet of documents, the first page of which says Media Alert. Do you see that?
Yes, I do.
And is that a packet of documents that you and your attorneys put together to distribute to media people at your press conference?
Appears to be.
And does it say that the purpose of the press conference is Dr. Jerome Oziel and Mrs. Laurel Oziel will respond to the allegations made by Lulow Smith?
That's what it says.
And it says your press conference is going to be held September 13th, 1990 at 11 o'clock in the morning at the Beverly Hilton Hotel.
That's what it says.
And then it's followed by a biography of you, correct?
That's correct.
Setting forth that you hold 4 specialist certifications in the areas of your expertise.
I don't know what it says. I haven't read the biography.
Well, take a look at the last line.
Okay. Okay, that's what it says.
And the whole page has to do with your, basically the same information that, or some of the information that was in your CV that Ms. Abramson questioned about Dr. Jones.
Yes, I don't know what the rest of it is. I didn't look at it, but I'm assuming that's so. Okay.
And followed by the bio is a statement of your lawyer dated September 13th, 1990.
That's correct.
This is a document that was handed out to the press, right?
That's correct.
And then followed by that is a statement to the media by L. Jerome Oziel, PhD.
That's correct.
And the first sentence of it says, ladies,
Objection hearsay.
suffered for a non-hearsay.
You have that document there? Do you know what he's reading from?
Yes, I know what he's reading from.
All right, let me see what it is.
I'm just going to read the first sentence.
Oh, the first paragraph?
No, the first sentence. Right?
You say the first sentence, you're talking about the first sentence of the first paragraph?
Yes.
Is it hearsay?
Right.
It is an out of court statement. Definitely is that.
All right, the objection's overruled.
Ooh.
Say in your statement to the press, ladies and gentlemen, I consider myself a private man, correct?
That's what it says.
And then you go on to make several statements about Judalon Smith, correct?
Ooh.
Correct.
One of the statements you make is Judalon Smith was
Objection
never,
hearsay.
Right, we have a foundation as to whether he's the author of this document.
yes. Doctor, did you compose this document yourself?
No.
It's presented as the statement of L. Jerome Oziel, PhD, correct?
Correct.
Did you adopt the statement? In other words, was it written by someone else and you read it to make sure it contained your thoughts and then you presented it as your own statement?
It was basically prepared by, I think, attorneys and some other people who were advising me. I did read it over.
Right. And did it, at the time it was presented, accurately reflect statements that you yourself wanted to convey to the media?
That's my recollection.
And is one of the statements you conveyed to the media that Judalon Smith was never my patient, I never provided her, nor did she ever request, either formally or informally, any psychotherapeutic services?
I certainly did.
Uh-oh. That's not what that
You
letter
also say
says.
in reference to Judalon Smith that Judalon Smith relentlessly pursued a committed relationship with me, which I rejected, which I repeatedly rejected.
Yes, I did.
Did you also say that Smith had extreme and unreciprocated feelings and designs toward you?
Basically, that's what that says.
What it says is, over the entire course of my knowing Smith, she continually wrote me dozens of obsessive letters, which
Jeez.
clearly exposed the extreme and unreciprocated feelings and designs she has toward me.
That's correct.
And you also described her as having an unreciprocated fixation on you, correct?
That's correct.
Now,
Whoa.
is it true that it was really the other way around? That is, that before this session on October 31st, where you testified to what the Menendez brothers have said, that you were obsessed with her?
No.
Absolutely not.
Isn't that what projection is? In other words, you're describing her as
Oh.
being fixated with you when in fact you're the one who was fixated.
No, you're using the term inappropriately, and you're also assuming or trying to imply that it applies. It doesn't apply at all. No, it's not the reverse. It's absolutely false.
Whoa. Whoa. Basically got him to like, regardless of, I mean, of course he's not going to agree to that, right? On cross-examination, he's not going to agree to a statement that asks, or a question that asks, like, were you really the one that was obsessed with her, even though you went out to the press and said that she was obsessed with you? But like, was it really the opposite? Like, he's not going to say, oh yeah, actually, now that I think about it, yeah. So like, it doesn't matter what he says. The thought has been planted in front of the jury so that they can think about it and say, you know, this guy's a little weird. He's a little off. He's got some weird obsessions. And he's trying to spin this about the girlfriend in all of these weird ways. Isn't there a possibility that maybe he's also doing that to the Menendez brothers? That's the thought process that they want, him, or that they want the jury to be thinking. Kit Kat, would you consider this one of the best crosses you have seen? I think it got off to a little bit of a slow start, but it definitely is humming along right now, that he's just sort of methodically working his way through it. It is definitely a good one. It is for sure a good one. I will say that. I especially coming out of the Paltrow trial, this lawyering is so much smoother.
Now, is it your testimony that prior to October 31st, 1989, that Smith was pursuing you?
Yes.
And is it also your testimony that you were basically trying to get away from her?
Yes, that's correct.
And is it true, showing you Exhibit 113,
Mhm.
that these are your phone records from one of your phones at your home in Sherman Oaks?
Appears to be.
And those phone records, do they not show One of your phone numbers is 818-906-8853. And the first record is dated October 16th, 1989. And it goes all the way through February 16th, 1995, correct?
I don't know, you haven't shown it to me.
Let me show it.
Okay. Okay, that appears to be correct.
And it's showing you Exhibit 114. Is this a set of phone records from your other phone at your home, which is area code 818-907-5083?
And it appears to be. Okay.
Right? And returning down to 113, you'll see in the phone records themselves, there are highlighted certain numbers. Do you see that? In
Correct.
yellow. And the numbers that are highlighted are area code 213-931-0069. And the second number that's highlighted is 213-655-3031. Do you see that?
Right.
And those are the numbers of Jerome Smith, isn't that true?
I don't recall, but they probably are.
And you'll notice that beginning in early September, actually mid-September, September 18th specifically, you or someone in your home is calling that number repeatedly, day in and day out. Isn't that true?
I don't know about day in and day out, but there are a lot of calls to that number.
Well, when I say day in and day out, I mean that on September 18th, you called her at 8:39 a.m. and talked to her for 42 minutes, right?
That's correct.
By the way, that would have been you making the calls, right?
I'm assuming so.
No reason your wife would have been calling your lover, correct?
I don't think so.
And the next call on that same day, September 18th, you called her, after you talked to her for 42 minutes, you called her at 9:25 a.m. and talked to her for 1 minute, correct?
Appears to be correct.
You called her at 11:01 a.m. and talked to her for 4 minutes, correct?
Appears to be correct.
You called her at 9:39 p.m. that night, and talked to her for 40
Definitely
minutes,
making him look
correct?
like the obsessive
correct.
guy.
You called her at 10:23, talked to her for 23 minutes, correct?
Appears to be
Jeez.
correct.
10:51 p.m. on the same day, you called her, talked to her for 13 minutes,
That appears to be correct.
correct? And just on this one page, which deals with September 13th through the 29th, there are 19 calls made to her, correct?
19
Yeah, the
calls?
vast majority of them were 1 minute, 2 minute, 4 minute, so on and so forth calls, but there are some longer calls on it. That's correct.
And on the next page, which covers
That's
the
just the
period
first
from
page.
September 29th through October 16th, on one page, you have called her $35 times, correct?
Whoa.
I didn't add them up, but it looks like I've called her quite a few times on that page.
The whole page is basically covered with her number, is it not?
Well, it's probably the only total number that I was calling for the most part, but yes, there are a number of calls.
And those calls varied from 1 minute up to, looks to be 20 or 30 minutes in length, correct?
I'm looking at the times. Where are they? Here? Yeah, I can't even read the numbers. Most of them look like they're single digit numbers, like 3 minutes,
Carnegie,
5 minutes,
that's a good
3 minutes,
question.
2 minutes, 1 minute, 2 minute, 3 minutes. There are most all of these calls are 2 minute calls.
All hours of the day.
I don't know if I characterize that, but most all of these calls, I actually only see 3 or 4 long calls in this whole period of time, which is basically a period of 3 weeks. Most all of them are 2 or 3 minute calls, 4 minute calls, 2 minute calls, 1 minute call, things like that, which basically is hello, goodbye.
And I see so you say over a period of month, I see on September 30th, you called her at 3:52, 6:42, 8:49, 9:54, correct?
Looks like it.
And was that all hello and goodbye?
No, there were a lot of issues that we were dealing with. Many of them, there are all sorts of issues that we were dealing with at that
And
time.
that was you calling her, right?
That was me calling her.
And the next page, same thing, right? Page is covered with calls that you made to her.
Page is
from October
covered with
17th
calls you
through
made to
October
her.
24th, all from your own, different times of the day and night, all made to Miss Smith. Isn't that right?
Again, most all those calls are 1 minute calls. Some of them are longer, but 1, 1, 1, 1, 1, 1, 2, 1, 1, 1, 1.
Well, you skip one there, 61.
There was a 1 hour call, but most of those calls were 1 minute calls.
And the one after the 61-minute call.
Mark,
It's a
I remember that
15-minute call.
commercial.
And 20 minutes and 22 minutes.
Just to save time, there probably are 1, 2, 3, 4, 5, 6 calls that were of any length at all in that all the numbers you just pointed out.
And that's all before October 31st, right?
Yes, that's before October 31st.
You see the next page goes from October 26th through the end November 15th, and you have probably 25 or 30 more calls. Miss Smith.
Again, very much varying in length, but yes, there are a number of calls to Ms. Smith.
And the same with 114 from your other phone number shows numerous calls, all hours of the day or night made to
boy.
Miss Smith, does it not?
Well, I wouldn't. The all hours of the day and night is yours, but basically, there are a number of calls to Ms. Smith. That's correct.
Just as an example, October 6th, you called her at 10:58 p.m., correct?
I don't know. You're holding it too far for me to see. Okay. You're talking about. Okay. Yes.
And you talked to her for 268 minutes, did you not?
That's what it appears like.
That wasn't just hello or goodbye, was it?
No, that probably wasn't hello or goodbye at all.
And on that same page, on one page going from October 2nd to October 11th, you called her. Calls range 10 minutes, 65 minutes, 23 minutes, 268 minutes, 49 minutes, 27 minutes, 15 minutes, 18 minutes, 17 minutes, 23 minutes, 56 minutes, 17 minutes, correct?
Yes. Spread amongst again over that entire period of time, a lot of 1 minute calls.
So who's being obsessive here, doctor?
Judel and Smith.
And isn't it true that in these telephone conversations,
Bullshit.
where you would call up,
That's what that
that
translates
she
to.
would sometimes not be there and not return your calls, and you would constantly call back and say things like, call me back right away, tell her she was crazy, and keep repeating the same message over and over again. And she would refuse to return your call. Isn't that true?
Objection calls for hearsay, calls for speculation, and is compound and complex.
Weren't there days, doctor, when you would call up Judel Smith and she would not be home and not be returning your calls, and you would keep calling back over and over again, leaving her messages to please get in contact with you?
No, I don't recall that. And the nature of the messages was not to please get in contact with me.
Let me, if I could have next more, exhibit 115.
Be 116.
116, sorry.
Can we approach, please?
Exhibit
All right.
116. Is this
Before
going
it's
to be the
marked, you
phone
may
call?
approach.
Doctor, all those phone calls I read to you were made before October 31st, 1989, were they not?
Yes, they were.
And is it true that before October 31st, 1989, the weekend before that day, that you and Ms. Smith went to Arizona together,
I don't recall that.
flying under the name of Mr. and Mrs. Jerome Oziel?
I don't recall that.
And is it true that on the 28th or between the 28th and the 30th of October, regardless of where you were, that you and Judel Smith got into a lover's quarrel over something having to do with jealousy?
I don't recall anything about that.
That may have happened, you just don't remember.
Yeah, objectives are being irrelevant.
What was the date of the inquiry?
Between the weekend of October, or the days of October 28th to the 30th, 1989.
Overall.
I don't recall that.
have a one-page piece of paper.
All right, that'll be 116.
Didn't we have to take them?
No.
Doctor, showing you what has been marked as 116. Do you recognize that as a receipt with your name on it and a boarding pass to an airplane?
Yes, appears to be.
And is the receipt to a place in Tempe, Arizona called Westcourt in the Buttes, B-U-T-T-E-S?
Yes, it is.
And is that in the name of Oziel / Judalon Mister?
That's what it says, right?
And is there also a boarding pass?
There's a boarding pass.
Does that refresh your memory as to when you were in Arizona with Judalon Smith?
Yes, it appears to.
When is that?
No, I mean, I'm assuming that if that's the date that you got these from, I'm assuming that that's, I don't see anything that has a date on this, or does it? Is there a date on here somewhere?
Well, it may be a little faint, but my question is whether you can use that in any way to refresh your memory.
No, I don't remember when I was in Arizona. So if there's a date on here, that would refresh my memory.
In any event, do you remember just before you had these sessions on the 31st that you and Judalon Smith had an argument which resulted in her basically saying she didn't want anything to do with you anymore?
No,
You laugh at that, correct?
it's absolutely not true.
All right. Is that as absolutely not true as your statement before lunch that you absolutely did not diagnose her?
I think I-
Objection sustained.
And it's your testimony then that there was no point in time right before the sessions with the Menendez brothers where you got into an argument with Judalon Smith. Is that true?
No, I didn't say that. Anybody can get into an argument at any point. I just don't recall specifically having had an argument at that time, and I definitely don't recall any argument such as you described.
Well, let me ask you a broader question. Was your relationship with Miss Smith troubled in any way just before these sessions with the Menendez brothers took place?
It certainly was.
And was one of the reasons why you were making all those telephone calls because of the trouble between the two of you?
One of the reasons I was making all of these telephone calls, or a lot of them, had to do with Judalon Smith obsessively calling me and wanting reassurance and trying to elicit me calling her. And in addition, she couldn't call me at my home, so she asked me to call her very frequently. So it was at her request that I made these phone calls.
Including the 268-minute one?
That doesn't
Absolutely.
jive.
No different than the other one. She was requesting that I make those phone calls. So,
Go ahead.
no. So basically, this is a completely distorted record. The reason it's distorted is that it only involves, it doesn't acknowledge the fact that she was asking me and calling me and trying to find ways to get me to call her frequently, asking me to call her extremely frequently. And in addition to that, telling me that she couldn't call me where I was located because in the one instance I was in my office, in the second instance I was at my home.
Did she have some way to keep you on the phone for 268 minutes?
We talked. We had a relationship. We had a business relationship, a personal relationship, both. It started out as a business relationship, and I might
And a
add,
doctor-patient
a great many of
relationship.
these calls were business calls. They were not personal calls.
At 10:58 at night for 268 minutes was a business call?
May very well have been. We were planning multiple business projects.
And are you saying that all those phone calls day in and day out in the period before October 31st were prompted by phone calls that she made to you saying, please call me up, Dr. Oziel, or words to that effect?
I think that there's a tremendous amount of documentation that I have in writing that, yes, she was repeatedly requesting me to call her and asking me to be in contact with her very, very frequently.
And I
And
guess,
move to strike that answer for the part that's not responsive
Right,
and
the
hearsay.
objection is sustained, the entire answer is stricken.
I guess that'd show up in her phone records, wouldn't it?
All right, counsel, we don't have a question that relates to an answer, so you'll have to rephrase your
All
question.
right. Doctor, are you saying that she made phone calls to you that are, at least on the face of it, as obsessive appearing as your phone calls to her?
I didn't characterize these as obsessive at all. You did. And no, what she did is write me dozens and dozens of letters that contain that content and engage in extremely frequent conversations that were, insecurity based and really asking me to frequently call her and be in contact with her, which is that and the business things we were working on account for the phone calls that I made and the fact that she couldn't call me.
I haven't
And was that
seen
the
said
only
letters.
inducement she gave to you? In other words, she would give you letters saying, Jerry, please call me, and then that would produce all these telephone calls?
I didn't say that.
Well, was there something else she did that caused you to make those phone calls day after day,
She
hour
threatened-
after hour,
She threatened.
minute
me.
after
So-
minute?
There wasn't minute after minute.
Well, do you want to go through them again, Doctor?
Objection argumentative.
Objection sustained.
Yeah, that's a little argumentative.
Was there some other device that she had for causing you to make all those telephone calls?
I think I already testified that we were involved in business discussions and a personal relationship, and she verbally requested me to call her extremely frequently. As a matter of fact, if I didn't call her, she became very insecure and extremely unhappy.
Now, Doctor, is it true that from the period between October 31st, 1989, and the time when the search warrant was served at your house, that you at one point suggested to Judalon Smith that she should call your wife and disguise her voice as Eric and tell your wife, hello, Laurel, this is Eric, you're in trouble, I'm going to kill you? Did you suggest that? You laugh at that?
It's absurd. No, I did not.
Your Honor, at this time I have to take a break because I'm at the point where I need to
All right.
make an offer of proof.
Okay, we'll take a recess and we'll resume at 10 minutes to the hour. Ladies and gentlemen, don't discuss this case with anyone. Don't form any opinions about it. We'll resume at 10 minutes to the hour. And all people in the audience, please remain until the jurors have left the courtroom. And these were tapes that were provided.
Okay, there was a question here. Ellen, not Sarah Lee. Can you explain objection argumentative? So it's when we're talking about someone during a cross-examination, it's basically when, I mean, it's generally going to come up during cross-examination as opposed to direct, because it's when things get a little contentious between the attorney and the witness. So he I can't remember exactly what the attorney said, but he made some kind of a statement that basically it doesn't really ask a question. It's more like a statement of like you're being really difficult, or what you said just doesn't make sense, or what you said was BS. Like something along those lines. If it's not really geared towards asking a question and moving the testimony forward, but you're kind of just like making a snide remark to the witness, then that can be objection or argumentative. Now, this court is particularly sensitive to that kind of thing. Like they are like super prim and proper here with this, which I think is probably the reason why Judge Weisberg doesn't seem to like Leslie Abramson, or Abramson. I think Abramson. Anyway, so why I think that's why he doesn't like her, because her overall style is a bit more argumentative. Also, defense attorneys can often get away with it more so than prosecutors can, because they they're going up against the state, and so they're zealously advocating for their client. Of course, every attorney has that duty, but it's a little bit different when you're representing the state as opposed to an individual who can lose their freedom if they lose the case. So, but this particular court is a bit more prim and proper on some of these objections than some other courts would be. I don't think that Judge Penny Escarate in Fairfax County was this strict on those kind of objections, because it's like a lot of judges would say, look, this is cross-examination. It's meant to be tough. It's meant to be, like putting the witness in the hot seat. And so, like if there's some contention going on between the attorney and the witness, that's sorry, it's cross-examination. So, but here, however, judge is being super strict on that.
Added to the defense by the prosecution.
Yes, Your Honor, discovery.
What did you post it?
Your Honor, as to tape number 47, and I would like to play, I have the tape advanced to about midway. In the beginning of the tape are other phone messages incoming into Miss Smith's home from other people. About midway through the tapes, starts a series of calls from Dr. Oziel, pretty much one right after the other, and I have the tape set to begin when that call comes in.
Are these time coded in any way?
They're just, there's an indication of day and time, but not days. And it's my.
Day of the week and time?
Yes, correct. It'll say Monday, 1 o'clock.
Okay, Revian, I was thinking the same thing.
March 5th.
Minute after minute,
And it's
hour
right
after hour. Okay, yeah,
these
yeah. Okay, I'm glad. I'm glad that I wasn't the only one not going
statements
crazy.
were made sometime between October 31st, 1989, and March 8th, 1990, when the search warrant was served on Dr. Oziel's residence. And there will be testimony to that effect from the city.
Well, is it any more precise than that? Does it relate to the period in close proximity to October 31st or more in the area of March the 8th?
I think it's probably more in the area of March the 8th.
And you wanted to play that now?
Yes.
Record and-
Ooh, putting the boombox out again.
There'd be a stipulation.
Hopefully, we can actually hear it. And this is not in front of the jury right now, by the way. They're determining whether or not this can come in. Oh no, you can't hear it.
Is that what you intended to play?
No,
No, excuse me, I want to make sure that tape recorder is not on the radio mode. Yeah, that's-
please. I think I had it in the wrong way. I think it should. And I'm gonna have to
Is
back
that-
it up.
see, I think it's
If you can call me here between now, which is 9:33, and 10 p.m., I'd love to hear from you. So if you can, 981.
This phone message actually would not be played.
There you go.
It's the next
See you
few.
later. Monday, 9:31 p.m.
Hi, Jerome, it's Donna.
And again, this would not be played. This is
The
legal.
brother phone period. Call me back.
Tuesday, 11:14 a.m. Hi, it's Wes. Can you give me a call, please? You have my number? Thanks. Tuesday, 11:36 a.m. Hi. I'm just concerned about you. I haven't heard anything from you in the last 2 days. I know that you have been to the store, and I'm just worried about how you're doing. And I thought it'd be good for us to talk, to deal with whatever feelings you're having and whatever you're going through, because no matter what, I just want to make sure that you're okay. So, why don't you give me a call as soon as you pick up these messages, and you can give me a call in my office, let me know that you're all right. And you know the number, it's 2780817. So as soon as you pick up the message, maybe you can give me a call at 2780817. Just let me know that you're okay. And maybe we can talk.
Definitely sounds like someone who's saying, "Don't call me."
Take care. Bye-bye. Tuesday, 11:59 a.m.
Hi, Jerome, it's Donna. I was just calling to see if you have left yet. It's 1:36. Did you call when you heard this message? Because I have just something I need to tell you. So I will talk to you later.
Tuesday, 1:38 p.m. Hi, JR. This is Robert. The time is about 6 p.m., okay? On Tuesday. And guess what? I'm going to remind you something. I dropped by the shop. I picked up 2 blank checks. I deposited them in your mailbox. So that I might have some operating expenses for the shop, okay? So the checks are there. All right. By the way, okay? Bye-bye. Tuesday, 5:58 p.m.
Oh boy.
Take care. Bye-bye.
That's someone that sounds a little obsessed.
Tuesday, 6:57 p.m. Tuesday, 7:01 p.m.
All right. So now I'm going to fast forward through to testimony because
And,
let's see. Even though like it's pretty good stuff, but I
from
do
him,
want to
and
see.
so I will skip to the point in time.
Okay, so they're figuring out what they're going to play in the courtroom.
It is.
I want to see it when they get to
These were-
playing it.
So that's something that you can
Okay, let's
pursue.
see.
let's stop this nonsense.
Because you made me fear for your life that they were going to come into the office and kill you.
They might have.
Whoa, hang on. I want to go back a little bit.
October 31st and said he did not recall. He told me that he did not recall her being there on the 31st, but that he recalled her being there on November 2nd.
You're saying during his cross-examination today or on some earlier
No, this
day?
was, it may have been yesterday. That he was talking about.
On
I don't think it was
Friday of
yesterday.
last
Friday,
week?
Friday last week.
Okay, so this was a statement made to you by Dr. Oziel.
Yes.
That we're just getting discovery of at this moment, Your Honor.
All right, so that's something that you can pursue with the witness if you care to, Mr. Burt. And if
Okay.
you want to play that tape now, you can listen to it to expedite the matter.
So these will also be played during Judalon Smith's testimony.
And based on that statement, Your Honor, I think the context of this will be October 31st, but
Better let me talk to your attorney. I swear you better let me talk to your attorney. What you're doing, or what you're thinking of doing, is absolute insanity. You've got to stop this. You've got to stop this. You literally need to talk to a psychotherapist, and you literally need to let me talk to your attorney. I've got to
Jerry,
get back.
nothing is wrong with me.
Judy,
I know the truth, and you placed my life in jeopardy by putting me in that office and putting me in that room and letting those boys see us
over and over and over again, and you're the one that duplicated the tapes. The bottom line is, look, let's stop this nonsense.
Because you made me fear for your life that they were going to come into the office and kill you.
They might have. Yeah, here, you were there.
I know, and so unfortunately now I know because I overheard the stuff and I saw them and I know, and you told me word for word everything that happened in those sessions.
You don't know a lot of things that happened, and a lot of what was told wasn't even accurate.
Jerry, you were not lying. You gave the session word for word to me and to Laurel. All the sessions.
Yeah.
You forget that.
Did you tape record the session last night or this?
so Your Honor, I would. Keep the place
She's just like, what an idiot.
so you don't know a lot of things that happened, and a lot of what was told you isn't even accurate.
Wow. Judalon Smith has not
Right,
yet testified.
you
Okay,
just
let's
respond.
let's go
the
forward
jury.
then to when the jury gets in. Okay, there's more phone calls that they're going through.
Was it just from the
I'm not sure whether
Okay, so yeah, they're still going through. I think it's probably going to be
Well,
past
the
this
New
other
Jersey-
red line,
if the jury.
but I just want to be sure.
The nature of the conversation, that
Okay.
we're brief on the subject.
Okay, I think this is going to be more testimony.
The jurors are not present, and the
Oh,
parties are otherwise present, and want to discuss something.
Yeah, sure, Honor. I just wanted to clarify
Okay,
one
we're gonna
aspect
fast forward
of the
through this
court's
as well.
ruling, which is
okay.
Doing is
Fast forward as they are
examination.
discussing
2
with the
days.
judge. Do.
Each time I
Oh.
saw her,
Hang on. Okay.
All right, let's resume with the trial.
Here we go.
Both jury panels are present, and Dr. Oziel, would you get back on the witness stand, please? Mr. Burt?
Thank you. Sir, just to back up for a minute, you stated that all those phone calls that are indicated in the records that were shown to you were made because Judalon Smith kept pressing you to make them. Is that a fair summary of what you were trying to say before?
no, I didn't say that all the calls were made because she was pressing me to make them. I said that in general, we had, there was an
Backpedaling.
agreement that she couldn't call me at work. It was not possible because I had an answering service. There was no way to reach me. And she also couldn't call me at home because I was at home with my family. So she implored me to call her very frequently, verbally, each time I saw her, and also in writing. And for that reason, you would note that the calls emanated from my number to her number. A good portion of them were business calls. We had a number of business projects we were working on. Some of them were personal calls, and then a very large percentage of them were brief calls, 1 minute, 2 minutes, leaving a message on her answer machine.
Doesn't really matter
what
what his answer is.
And those telephone calls, those brief calls were basically one of the situations where those calls were made was she ignoring you and you relentlessly pursuing her. Isn't that true?
Yeah,
No.
it calls for a conclusion and a guess on the part of the witness.
Overruled.
In
No,
other words, you said in your,
Wait, we haven't had an answer to
I'm
that.
sorry.
no, that's not correct.
You said in your press release that you gave to the media that Judalon Smith relentlessly pursued a committed relationship with me, correct?
That's correct.
And you said she had an unreciprocated fixation on you, correct?
That's correct.
And I asked you before the break whether or not it was just the office, correct?
That's correct. And I said no.
And isn't it true that you were the
So, Debbie, just to interrupt real quick to answer this question, what does this have to do with the boys? Well, this has to do with this character, or this witness's character and reliability and credibility, because he said all kinds of things about the Menendez brothers. He also said all kinds of things about his wife and about Judalon Smith, particularly Judalon Smith being this crazy person. And so this is important because this is showing how he has completely mischaracterized another person, according to the defense, right? And we're gonna see this played out. I mean, obviously, we just got to listen to some of these recordings through the recess, but the jury has not heard them yet. So this is just setting up the jury to completely disregard anything that he says about anyone else involved in this whole thing, because he has clearly lied about the girlfriend. He's completely mischaracterized her. He's labeled her as this crazy person who's obsessed with him, and he's just trying to get away from her. And yet he invites her over to his house, and then he calls her a million times. And then the voice recordings indicate that he's like super, super into talking to her, not calling her to say, "Don't call me." Nothing like that, right? So the logic then goes, well, what about all of his characterizations of the Menendez brothers? Are there reasons why he might have an interest in characterizing them in a particular way that is incorrect? So it really comes down to his credibility. Even though it's not exactly about the brothers, it comes down to this witness's credibility about the things that he has said about individuals, and those things not actually being true.
were the one that kept calling her up and having her asking her to call you back at your office? You said she couldn't call you at your office, right?
Yes, she couldn't call me at my office, and she also couldn't call me at home. So she basically couldn't call me at all. So therefore, she needed to talk with me. She had to call me back, but it wasn't because I was pursuing her. It's because that's the only way she could be in any contact with me.
And I want to play you exhibit 118. You can just take 47.
Here we go.
47 is exhibit 117.
This is take 47, 117.
Yes.
Thank you. If you could just listen to this, Doctor, a portion of it.
All right. Just calling to find out if you're okay. I called Donna to find out if you were okay, and she said that, I didn't ask if you were okay, I just asked if she heard from you, and she said that she hadn't heard from you at all. She was surprised, a little concerned. So just wanted to make sure you're all right. Take care. Bye-bye. Tuesday, 6:57 p.m. Tuesday, 7:01 p.m.
Is that him just breathing into the phone? Someone making popcorn? Is that what's going on? Oh, I get it. It's the popcorn break for the next mic drop for this witness. Oh my God. Stalker vibe.
And Donna said she hadn't heard from you for a couple of days, so I was concerned about you. So I said, stopped by, and I got the feeling that you had told Michael and perhaps your next door neighbor, Robert, or whomever, who was there but didn't answer the door.
He was talking to all the neighbors about her.
To be talking with
Looking under her car.
If that's the case, why don't you just let me know? Because I was really just concerned for you and trying to help you and trying to make sure that you're okay.
He's definitely pursuing her.
That was the only point of my calling, and I've been concerned about you for 2 days because I'm real worried about you knowing what's happened in the past and how depressed you've got. So, just let me know if, in fact, for some reason you decide not to, or that you don't want to speak or have contact, if that's better for you, then just let me know. It'd be a lot easier and more reasonable. If I really just was real concerned about your welfare. I'm assuming that you're okay, since Michael wasn't concerned at all about checking your apartment and was very resistant to it, and said that he was sure that you probably really weren't there, but he couldn't tell for sure. So if you are there,
He was resistant to talking to him?
Everything looks fine, and then that'll be that. That'll be fine. If you want to talk, you can let me know. Take care. Sure, I'll pick up the phone. Are you there? Or weren't you really there? Are you really not at home? July. Tuesday, 11:33 p.m. Hello. If you're there and at home, and if I can believe anything you said about being home, please pick up the phone now.
11:30 at night.
If you're home, July, please pick up the phone. I didn't think you were home. In fact, I was sure you were home. Tuesday, 11:34 p.m. I'm going to assume you were talking about somebody else and not at home. Absolutely, if you don't pick up the phone now. I guess you weren't home, were you, July? There's another lie. You're dangerous.
You're dangerous. Jeez.
Tuesday, 11:35 p.m. Yes, Miss Smith, this is Lieutenant Griffey of the police department.
Was that your voice on that tape, Doctor?
Certainly was.
And that is you making a number of calls to Ms. Smith. Is that correct?
No, that's correct, but the connotation about what it relates to is completely distorted.
Is it?
Now, Doctor, I think you said at your press conference that Smith was never asked to eavesdrop on any of your patients in therapy, nor do I believe she ever did. Do you remember making that statement?
Yes.
And is that statement false?
No, that's not false.
Did she, to your knowledge, eavesdrop on your patient sessions?
I don't know if she eavesdropped. I know that I never asked her to eavesdrop, and she was in the office at some occasions. She could have eavesdropped, but I definitely didn't ask her to, and don't believe she did.
I didn't ask her to.
She
I don't
asked
feel that's
you
true.
over and over again to be in the office at the time that you were having sessions with the Menendez brothers.
Yes. I wouldn't say over and over again, but she did on several occasions.
And did you say, okay, you should be there and invite her in to be at the sessions?
No, I said the opposite.
That she shouldn't be there.
That's correct.
So to your knowledge, she was not present at the October 31st, 1989 session, correct?
That's correct.
And according to your testimony here under oath, she wasn't present for the November 2nd, 1989 conversation either, was she?
I don't believe I testified to that under
Well, I'm
oath.
asking.
Well, I think she was there November 2nd, 1989. Absolutely.
Where was she?
I think that she was in the waiting room at some point.
And was she there pursuant to an invitation that you made or that she had asked you over and over again to be there on November 2nd?
No, she was there pursuant to her own insistence on coming when I told her not to come.
Don't
And
believe that.
was she in a position where she could overhear?
Again, I'm doubtful that she could have overheard anything at all from the waiting room. I don't believe it's physically possible, but if there's any physical possibility that one could overhear something from the waiting room, then it's theoretically possible. I don't believe it.
Well, do you remember having an argument with her where you were saying, come on, Judalon, you were there. You know what happened. Do you remember saying that to her?
No, but if I said that, it wouldn't probably be referring to what you're referring to now.
Right. Let me, if I could. This is page 46.
118.
118.
For 25 hours about this for over months to attorneys. Every single one of them, when they understood the circumstances, said,
Excuse me, Your Honor.
if there's
I
any
believe this is not- this is not what he was going to do.
Uh-oh.
You know how when you sit in the movies, you always. If you're not trying to threaten me and scare me, then why are you?
If you can't
I'm
find
going to do you to turn them in. I guarantee.
Excuse me, Your Honor.
You know, I mean,
Mr. Burt,
Uh-oh.
if you don't have the cue to the right spot, you just have to go on something else.
Uh-oh. He's got to find the right spot. See, it's so much easier nowadays when you can just have the audio file already like cut and spliced ahead of time. But yeah,
Now, Dr. Oziel, at some point
Genie's out
since
of-
you last
out of the
testified
out of
here,
the bottle,
someone
right?
played you that tape, which I was just about
yeah,
to
Lotus
play.
Flower, you can't unhear that.
No.
Did someone play a tape for
Whoops.
you during these court proceedings outside the court that indicated that you admitted that Judalon Smith was present at one of these sessions?
Absolutely not.
And is it true that today on the witness stand is the first time you have ever testified that she was present in the waiting room on November 2nd?
No, it isn't.
Where have you ever made that statement before?
Well, for one, Ms. Abramson was present at a meeting, I believe, with Mr. Chaliff and with the,
I would object without some kind of showing.
All right, let's have the question read back first. Objection is sustained, the answer is stricken. Let's have the question read back.
Question, and is it true that today on the witness stand is the first time you have ever testified that she was present in the waiting room on November 2nd?
Okay, the question has to do with whether you've ever testified, which refers, I assume, Mr. Burt, to a court proceeding. Is that correct?
Yes.
uh,
Your Honor, there was a question after that, actually.
That was the question that the witness was answering.
I don't recall whether I did or didn't testify or whether I was ever asked that question before.
Doctor, returning just for a moment to the sessions themselves on October 31st and November 2nd. I think you testified one session was about 4 hours and the second session, I don't think you told us how long that was on November 2nd.
I believe it was approximately 3.5 hours.
And is it true that a lot of those two sessions was you talking?
I would say some portion of those 2 sessions was me talking. I don't know how much of it.
Is it true that your general habit and custom in sessions with your patients is to be rather long-winded and to make long declarative statements telling the patient, or as you call them, the client, how the patient or client feels?
No, I don't think that that's my tendency.
Do you remember testifying in front of Judge Albrecht on June 15th, 1992? This is at page 1990, excuse me, at page 49.
Mhm.
49, yes. Remember making this statement, Doctor. Quote, "It is not uncommon for me to be long-winded, as probably people here can testify. And I do with patients sometimes go into long declarative sentences, even compound, that are very difficult to understand."
Excuse me, Your Honor. Is that page 49 of June 15th?
I gave that to you. Excuse me, may I approach the prosecution for a moment?
So why don't you approach the bench for a moment?
Uh-oh.
All right, the court sustains an objection to the last question as it was being phrased. You may rephrase the question.
And doctor, is it true that your pattern, practice, habit, and custom, whatever you want to call it, is sometimes in sessions to make statements to your patients for the purpose of eliciting their feelings? In other words, you'll make a statement that will prompt the patient to maybe express his feelings.
Definitely.
And was that process taking place during the October 31st and November 2nd sessions?
I don't know that that was taking place very much in the October 31st session, if at all. It probably was taking place sometime in the November 2nd session, because that's the essence of all counseling or therapy.
And what I'm trying to get at is these 2 sessions were not one-sided conversations between the brothers or them just talking to you. You were also part of this process.
Absolutely. I was
Would that
talking
be fair
to
to say?
Yes, that would be fair.
All right. Now, I think we have the tape ready. And I think I was asking you whether you had ever had an argument with Smith where you would acknowledge that she was present at these sessions, overhearing the content of the sessions.
These sessions, meaning,
October 31st and November 2nd.
I don't know. Well, first of all, I don't think I would have been having an argument with her over or having overheard anything the October 31st session, because I don't believe that she was there. But I could have had an argument that contained something about the November 2nd session. I don't recall. I mean, it was about 4 years ago.
As I understood what you were saying, it was that if she was there, at least your understanding was that she would not have heard any content of the conversation, correct?
The best of my belief, she would not have. I don't see how she could have.
So you, based on that, your own understanding of that, would not have been having an argument with her where you're telling her, June, while you're there, you heard what happened, words to that effect.
I don't know whether I would have said that or wouldn't have said it, but I don't believe she could have overheard the sessions from the waiting room.
Let me play you a portion of the tape and ask you if this is your voice.
I know the truth, and you placed my life in jeopardy by putting me in that office and putting me in that room and letting those boys see
over and over and over
me.
again, and you're the one that duplicated the tapes. The bottom line is, look, let's stop this nonsense.
Because you made me fear for your life, that they were going to come into the office and kill you.
Come on, they might have. Get out of here, you were there.
I know, and so unfortunately now.
So is that your voice on that tape saying, get out of here, you were there?
Yes, but it didn't relate to what you're inferring it relates to at all. Not one bit.
I don't believe it was a question. Maybe I need to start that.
I believe he had just completed his answer. Objection overruled.
Yeah. I don't know about
Pleased to know we're almost
that. I don't
Excuse me?
believe
I said
anything
you'll
that
be
he
pleased
says
to know we're
anymore.
almost done, Doctor. Doctor, when you were testifying on direct examination on August 4th, 1993, you were asked about a portion of the conversation you had with the brothers on November 2nd, page 9399, lines 2 through 11. And specifically, this was in reference to whether they told you they did it for the money or not. And you were asked a question, what were the elements of the discussion? And you answered, they were concluding that they really didn't kill their parents for money, but out of hatred that they had, in particular toward their father, and to be free from all of the abusive and onerous characteristics that the father had, dominating them, having them feel inadequate, inferior, extracting impossible standards, controlling their life, so on and so forth. What was the so on and so forth?
I'm sorry, that was such a lengthy question. I don't remember it. Could you please rephrase or restate the question?
Sure. Your answer was
Why don't you read the question so he understands what the
question, and again, the context of this is the discussion about whether they did it for the money. And the question was, what were the elements of the discussion? And you answered, they really didn't kill their parents for money, but out of the hatred that they had, in particular toward their father, and to be free from all of the abusive and onerous characteristics that the father had, dominating them, having them feel inadequate, inferior, exacting impossible standards, controlling their life, so on and so forth. And my question is, what was the so on and so forth you were referring to there?
I don't know that I was referring to anything specific, but that did sound like a long declarative sentence.
It did.
Yes.
Okay. And the so on and so forth was to indicate that they made other statements along those same lines, but you simply didn't include those in your notes or didn't have recollection when you were answering that question.
I was just meaning to refer to the fact that they made a lot of different statements, some of which I enumerated specifically, that all related to similar concepts about why the murder was committed.
Now, it's also true that you told them if you were threatened that there was no confidentiality. According to your testimony, they went ahead and threatened you, right?
No, my testimony was that Lyle, after that point, threatened me, not that they threatened me.
All right. And it was your testimony that you also told them that there was no confidentiality under those circumstances, correct?
I told them, right, that there would be no confidentiality under those
And
circumstances.
it's your testimony that Lyle nevertheless went ahead and made the damaging statements that you attribute to him, correct?
That's correct.
And I think you also testified that at the end of that November 2nd session, you were in great fear for your life, correct?
That's correct.
And is it true that at the end of that November 2nd session that you wrapped up the session by recommending to Lyle that he needed to establish a long-term relationship with you somehow?
Best of my recollection.
And did you have in mind that that long-term relationship was going to be a therapeutic one?
Yes.
Did you have in mind that that long-term relationship was one where you were going to get paid for seeing him?
If it was a therapeutic relationship, it would involve payment.
And did it also cross your mind that if you continued that relationship, that it would inure to your benefit financially?
No, I didn't.
Were you having some financial problems around the time of these sessions?
Uh-oh.
No, I wasn't.
Hadn't you just lost a lot of money, $1 million or in excess of that around November 1989?
Oh, no.
I don't recall how much money I lost, but however much money I lost didn't put me in financial difficulty.
And when you told the brothers that you could be of some potential use to them in the event their case came to trial, did you have in mind that that was going to involve some number of hours you were going to be working on the case?
No, I wasn't thinking particularly about that at all.
Did you have in mind that you were going to advise them on how to deal with the estate that they were about to inherit?
No, I was requested that I advise them or help them find advisors, if you will, about the estate. That was a request made of me that I find them independent people or help them find independent people to advise them. Was
your habit and custom at that time, that is October, November 1989, to establish a therapeutic relationship with a patient and then insinuate yourself into their business affairs and establish a dependent relationship where you would be in control of their affairs,
Whoa.
financial affairs?
Well, no, not only was that not my habit, but that is not what occurred at all.
And you hadn't done that previously with a number of patients?
And no, I hadn't.
You were on probation for doing that?
No.
No, I wasn't.
You were on probation for a situation with a court day for dual relationship, isn't that true?
It's true that I was on probation for a situation involving court day, but it didn't have anything to do with the statement you made earlier about insinuating myself into his life for financial benefit.
That had to do with you.
What? Holy crap. What a snake in the grass. That's insane. So he was on probation because he had basically like taken monetary advantage of a client and like put them in a dependent situation so that they had to continue working with him and he could just bill hours. And that's what he wanted to do. I mean, this is the insinuation on cross is that's what he wanted to do with the Menendez brothers. Holy smokes. That's wild.
With you bartering therapeutic services for construction work on your home, did it not?
No, that would be an inaccurate description of the situation. If you'd like me to explain it, I'd be happy to.
No, that's okay. Is one of the reasons are dual relationships prohibited in your profession because they allow the therapist to take unfair advantage of someone who is coming to you for emotional or psychological help?
They're to be avoided because there is always the potential that there could be some exploitation or simply conflict of interest in having such a relationship.
Yeah, there's the potential that the doctor could turn out to be Dr. Oziel.
And wouldn't one conflict of interest be in a situation where the therapist, who, by the way, the therapist-patient relationship gives the therapist a tremendous amount of power, does it not?
I think that the therapist has power in the therapeutic relationship. I don't know about tremendous amount.
Well, in the sense that the patient is coming to you with some emotional or psychological problem and is looking to you as a professional, correct?
That's the nature of therapy.
And is it true that one reason why dual relationships are prohibited is because the therapist, if he was unethical, could tell that patient that he or she was sick and then use that statement to the patient that the patient continued to need therapy as a basis for maybe getting something financial out of the patient?
You're asking me theoretical, hypothetical questions, and anything on earth, I suppose, is possible theoretically and hypothetically.
Well, for instance, if you had a patient and you needed some construction work done on your home and the patient was a contractor, one way an unethical therapist could work that situation to his advantage is to tell the patient, you really need to continue to see me. You need long-term therapy here. And if you stay in therapy with me, I'll cure you. And in the meantime, you do the construction on my home.
Objection.
Isn't that one way that an unethical therapist could operate?
Objection assumes that's not an
It's a hypothetical.
An unethical therapist could do anything. Are you asking me if that's what occurred?
I'm asking you whether that would be something that an unethical therapist could do to take advantage of a client and to come into violation of this dual relationship rule.
You're asking a compound question.
You cannot answer it.
No, I can't.
And is it true that that scenario which I gave to you is exactly what happened with you in court day? That's why you were on probation.
No, it's not.
Well, did he do construction work on your home?
He did some handyman work around the house. That's correct.
And did you agree as part of the settlement in that case that you were having a dual relationship with him in the sense of trading therapy for his assistance in reconstructing your house?
I agreed that, in fact, at the same time that he was involved in therapy, that he was performing some work around the house as a handyman. That was agreed to.
Yeah, and that's why you were put on probation.
For his benefit.
That's why you were put on probation.
Yes, the stipulation said that that my efforts were actually for his interest, and it was an effort to try to help him, and specifically stated it wasn't to exploit him, although it is technically something to be avoided. And there's no way that it was ever found, stipulated, or agreed to that in any way I was trying to harm that patient or any other patient. It simply said that there was a technical violation of that provision, and that was about 12 years ago.
Technical violation which landed you on probation for 5 years, correct?
Didn't land me anywhere, but yes, I was on probation.
And you had a supervisor that was supposed to watch over your work, correct?
There was a supervisor that I met with. That's correct.
And that was Dr. Lulow, wasn't it?
No, it was Dr. Lulow.
Lulow?
Yes,
And in fact, I think you testified it was Dr. Lulow that you called on the night of October 31st, correct?
that's correct.
And he told you could go to the police, did he not?
I don't recall that.
Well, if he did tell you that, would it be your testimony that you intentionally violated the advice that he gave to you?
Oh.
He didn't advise me to go to police.
Objection sustained, the answer is stricken.
Did you seek his advice on that night?
I sought his general corroborative opinion about what was happening.
And by the way, Dr. Jeffrey Lulow is the next witness immediately following him. So it's going to be really interesting to see what kind of testimony comes out of him, because this is the psychologist who's supervising him because of his probationary status. So very interesting.
And returning to this idea that you expressed earlier that you called a number of people, he was one of the people that you called and asked what you should do, basically, correct?
That's correct.
And he told you you could go to the police, did he not?
That was one of a number of options that he mentioned. He was not advising me or telling me to go to the police.
And you, on your own, decided not to follow that option, is that right?
Absolutely. He was not making any specific recommendation at all. He was simply trying to define the limits of confidentiality or help me define it on the phone. He was not giving me advice as to what to do.
Now, isn't it true that in addition to court day, you had a number of other patients where you had this habit or custom or pattern of establishing a therapeutic relationship and then insinuating yourself into the patient's business affairs at the same time you were telling the patient that he or she was sick and needed your help?
Objection irrelevant beyond the scope.
Objection sustained.
In your relationship with Judalon Smith, were you in a dual relationship with her?
Absolutely not. She was not my patient.
One of the reasons why you claim in front of
I know
this
that letter
jury that
says
she was not
otherwise.
your patient is because that would jeopardize your license. Isn't that true?
No, I claimed and stated she wasn't my patient because she never was my patient.
Well, you admitted under oath you were having a sexual relationship with her, correct?
That's correct.
And you deny that she was your patient, but isn't it true that having a sexual relationship with a patient is against the ethical code of your profession?
Certainly is. She wasn't a patient.
And in fact, you're under suspicion
you say
from the
that?
State Attorney General's office for that very thing. Isn't that true?
For what very thing?
For having a patient-lover relationship with Judalon Smith. Isn't that one of the charges pending against you?
It's a groundless charge, yes.
And you realize that if you admitted in front of this jury that you had such a relationship,
Yep.
that would jeopardize your license, correct?
That has nothing to do with my response, Mr. Burt.
Oh, but that's such a good question on cross to say. I mean, you do realize that if you were to admit that to the jury, you would be jeopardizing your license. So basically signaling to the jury, he has every motivation to lie on this question. Do not believe a single word coming out of this joker's mouth.
Judalon Smith was never a patient. She wasn't, she isn't, never has been, and she's not a patient.
My question is, is it your understanding that if you answer under oath here in court that she was your patient, that could be used in the proceeding that's presently pending against you, filed by the State Attorney General's office? That's my question.
Didn't think about that and wasn't concerned about that or aware of it one way or the other because she wasn't my patient.
Did you have a pattern and practice of getting involved with patients and giving them drugs
Your Honor,
as part of a method that, could I finish the question, please?
there's an objection. It's beyond the scope and it's irrelevant, and I think there's already been a ruling.
All right, the objection is sustained.
Sorry, did not mean to do that. Okay. One point here. This is a good point. Ultramarine 2 says he's a sleaze bag, sure, but every doctor has written a sick note for a relative. That doesn't make her his patient. but she's not a relative, and you usually don't have a sexual relationship with a relative unless we're talking about your spouse, right? In which case it's a little bit different. I think there might be an exception to that rule. There might be for spouses. So, because the thing is about the power dynamic, right? That's what it really comes down to. It's the same thing with attorneys and clients. There are rules about that. Different jurisdictions have different levels of strictness, but here we're talking about the nature of the relationship is different. And that's really what the crux is. And I think it comes down to the level of detail that's in that letter, where he says, I had an extensive consult with her where we talked about this, and he's diagnosing her. So, and he doesn't specifically say in the letter that he's diagnosing her. On the stand, he's saying, I didn't diagnose her, but like, if it walks like a duck, it talks like a duck, quacks like a duck. Yeah. Like, can you really say that it's not a duck? So, yeah. Okay.
Pattern and practice of getting involved with patients and giving them drugs
Your Honor,
as part of a method that. Could I finish the question,
Okay,
please?
sorry.
there's an objection.
I went back a little bit further than I needed to.
And it's
So.
irrelevant, and I think there's.
It's going to be sustained.
All right, the objection is sustained.
Doctor, at the very end of your direct examination, you testified that you were here under court order, correct?
That certainly is correct.
And I think you also testified in answer to Ms. Abramson's questions that you did not welcome the publicity which was coming your way as a result of this case. Was that your testimony?
It was my testimony, absolutely.
And I think you've already told us that you weren't under any court order when you held this press conference in September, correct?
Well, I was under a court order, but not that one.
Well,
I was under a court order.
Court order to gather a bunch of press representatives at a Beverly Hills hotel and hold a press conference.
No, I wasn't a court order to do that.
And is it true that you also interviewed in September of 1990 for an article in Playboy magazine?
No, that's not true.
Were you quoted at length in an article that was published in Playboy magazine?
I was quoted at length, but I did not interview for that. And as a matter of fact, there was a contractual agreement that was not to be used in any such publication, and it was used anyway.
Well, where did the quotes come from that were in the Playboy magazine article?
Some of the quotes came from me, and some of them didn't appear to have come from anything that I could remember. And there was a specific agreement that it was not to be used, a contractual agreement.
Do you remember you stating in the course of that interview with reference to Judalon Smith, quote, she might have gotten some information from other sources and then tried to place herself center stage as a person who held the truth in this matter and was a critical witness, end quote. Do you remember making that statement about Judalon Smith?
Yes, I do.
Is that an example of projection?
No, that isn't. As a matter of fact, what I was stating in an oblique way, because of the privilege that existed at the time, was that Judalon Smith would not have gotten her information by listening in at the door, but rather that the information she got from another source was actually me warning her that she was in danger and telling her some of the things that I thought she needed to know that she was in danger. And that what she did is retroactively place herself in the situation in a very melodramatic way and have herself as a central figure listening to all of this, when in fact, she never did any such thing and never heard any such thing. The way that she got the information she got was from an evidence code 1024 and a Tarasoff warning, where I gave her the information intentionally to warn her and to try to protect her from being harmed. That's where she got the information, not from dramatically listening in at a door.
And was that another long declarative sentence, which you just gave?
Mr. Burt, I would stipulate that that was a long declarative statement.
And doctor, is it true that after the search warrant was served on your house and there was some publicity in this case, that you called up a former patient of yours and was bragging to her that you were a big media star in this?
I don't even know what you're talking about.
Oh boy.
Do you know a person by the name of Cynthia McPhee?
Cynthia McPhee? That's
Yeah.
not a patient of mine.
Do you know her?
I knew her at one point. She's definitely not a patient of mine.
She lived in your house for about 5 years, did
She's
she?
a housekeeper.
For 5 years.
Yes, for a long period of time.
And your testimony is she was not your patient.
She absolutely was not my patient.
And after this case broke in the press, did you call her up and tell her you were a big media star now?
No, I did not. As a matter of fact, she called me. I don't recall calling her.
Did you ever place a phone call to her in Vancouver, Canada, in which you were bragging to her that you were a big media star as a result of this case?
I do not recall any such thing ever happening.
Do you remember a tape recorded conversation you had with Judalon Smith that was made at the request of the Beverly Hills Police Department in March of 1990?
Could you please repeat that?
Yeah. Are you now aware, as you sit there, that Judalon Smith was asked to wear a body wire for a meeting that she had with you, where you two had a conversation on March 7th, 1990?
Yes, I know that she wore body wear.
All right. And you've seen at some point a transcript of that tape recorded statement that was made as a result of that body wire, have you not?
I don't know that I ever saw any transcript of any of that.
Well, do you remember saying to Ms. Smith during the course of that meeting on March 7th, 1990, you read People magazine? Read People magazine. Did you read it? Smith, no, I didn't. Oziel, well, you're not in there, but I am. Smith,
Whoa.
so you love that sort of stuff. Oziel, fuck you and anything that looks like you. Do you
Whoa.
remember making that statement?
No, but it probably was appropriate at the time.
Jeez, what a dick.
I don't remember making the statement, but it didn't have to do with liking media. It had to do with not liking media attention. And when I said you weren't in there, I was, what I meant was you went to the police and initiated all of this. And basically, my name is in People magazine. It was not a way of stating I like publicity. It was quite the opposite. I was stating I didn't want the publicity.
Don't believe it.
Do you have a friend by the name of Cynthia that you contacted about Patricia, about a possible screenplay idea that you had for this case?
No.
Do you know a person, a friend of yours by the name of Patricia?
I didn't contact anybody about a screenplay with respect to this case, period.
How about a movie idea
No way. Didn't do it.
that involved somebody who was making threats to a psychiatrist on an airplane?
I never talked with anybody about any movie that related in any way to the Menendez case, period.
And never any script ideas about what you characterize as a fictional scenario of a psychiatrist who hears a confession on an airplane of a guy who is very prominent?
I don't recall any such conversation, but if there ever was any conversation about any kind of script, it had nothing to do with the Menendez case.
I want to see that. I want to see the documents. Impeach him.
Dr. Oziel, what did you do before you became a psychologist?
Objection, irrelevant.
What did I do before I became a psychologist?
Right.
I've been a psychologist ever since I graduated from school, so I can't really relate to that.
You started as a playwright, did you not?
I had an English writing minor in college as a playwright, but I didn't start as a playwright.
Well, didn't you start as a playwright and got a play published and got paid $50 for it?
That probably sounds like it could have happened, but that was while I was in school. I didn't begin a career as a playwright.
All right, and isn't it true that the
$50.
reason you went into
lot more in the
psychology was
90s.
that it was the closest thing to writing plays?
I wouldn't say that that's a complete reason that I went into psychology.
Was that one of the reasons you went into it?
I thought that it dealt with feelings and people, and feelings and people were of interest to me, and That's part of the reason I went into psychology.
Thank you, Sandra, for the super chat. This has been a masterclass in cross-examination and witness impeachment. I think he's done a fantastic job, just slowly and methodically, so long as the jury's still paying attention. Because longer cross-examinations can be tough for that. They can check out. So obviously we can't see what the jury's
You wrote
looking at.
this, did you not? This is on page 14. I then asked if they felt,
Excuse me, can we just have a chance to get the reference, please? Which part are you referring to?
page 14, second paragraph.
Your Honor.
Also, real quick, I'm going to interrupt this. There's only like 2 minutes left in this. Debbie Faison Cook says, I have another question. You may have already answered it. Sorry, no worries. Did the boys waive doctor confidentiality? We have not answered that. So thank you for the question. And no, there was a very big fight over the confidentiality issue of this witness. It went all the way to the California Court of Appeals. Came back down. They fought tooth and nail over it. So yeah, no, there was never any waiver. Gwendolyn SS says, question, is that the prosecution objecting? Yes, it is. Could the defense or the other brother object? Yes, they can. And in fact, Leslie Abramson in this cross-examination, you may not have caught it, but there were a couple times that she did object, but she wasn't objecting to the other defense attorney's question. She was objecting to the answer. He was kind of volunteering something at the very end of his answer at one point, and she objected to say that there was no question pending, but the judge disagreed with her and said no, like he's basically finishing his answer, which I think I kind of agreed with. And I can't remember what the other objection was that she made, but he actually did sustain that one. So yeah, the other party's attorney can also object one way or another. Their interests are aligned, the two defense parties here. So they're kind of supporting one another so far.
That's not true. It's at page 9416 and 9398.
People want to change their position or?
No, you're indirect.
Okay, hold on a second. What, page 14?
Yes.
Which paragraph now?
The first full paragraph starting with, I then asked.
Okay, hold on a second. Okay, my notes indicate that it was all missed.
I would have suggested.
I have that page.
We can approach you.
Sure. Well, let me just rephrase the question if I could. Recall at one point in your notes indicating that Lyle laughed. That Lyle laughed.
Sardonically, is that?
Yeah, don't
Right.
you indicate in this Lyle laughed rather sardonically?
Yes, I do.
Were you writing a play here, Dr.?
No, I wasn't.
Okay, that's all I.
All right, let me see counsel up here regarding the balance of this witness's testimony. All right, we'll be in recess until tomorrow at 9 o'clock, ladies and gentlemen. Both juries are ordered to return at 9 o'clock. Don't discuss this matter with anyone. Don't be exposed or let yourself be exposed to any of the news coverage or any discussions about this case or anything related to this case. And don't form any final opinions about it. We'll see you all back here tomorrow at 9 o'clock.
All right. So, okay. So that is that. And
real journalism.
Okay.
It's a way of looking.
We need to. Okay. There we go. Pause you. So, okay. Well, that is the end of Dr. Jerome Oziel as far as we can see so far. So unless they decide to bring him back, I don't know. Folks that have seen the trial before might be able to say, but that is 4 parts of testimony by Dr. Oziel. A good deconstruction of an otherwise very intimidating witness for the defense. I mean, he really would have been a great witness for the prosecution if he hadn't been such a scumbag and a completely unethical psychologist or psychiatrist. there was a question in the chat. I actually didn't catch. I thought he could also prescribe meds, so I thought it was a psychiatrist, but maybe not. Nia has a question. Do you think Michael Burt did a better job or Leslie Abramson? I honestly, I think both of them got bad information, bad for the witness out of him. So I think that they both were very effective. For me, they held my attention very well, but for the jury, I don't know. It really depends. So yeah, I don't know. They both were really good with this witness. And well, Ellen, not Sarah Lee. Here's a question for you guys. There is the next witness to go on the stand is Dr. Jeffrey Lulow. And his testimony is like 53 minutes. So we could power through it, or we could save it for next week. Let me do a poll really quick to see what you guys want to do. If we do, I'll just have to step away for like a minute and then come back. Let's see. Oh, Bright Eye says Dr. Oziel is coming back after Jeffrey Lulow. Okay. Okay, let's see. You could put Dr. Lulow on 1.5 speed. Okay, I mean, all right. So, okay. Then I might okay. I'll put this up for like one more minute. But it looks like the comments are pretty good. Y'all want overtime? So, yeah, let me just step away for 1 minute and then I'll be back and then we can continue on. So, give me 1 second. Okay. All right. So I'll end the poll. Okay. Okay, 1 sec. Okay. So hopefully you guys can all hear me. Let me just double check that. Okay. Yes. Good. Okay. All right. Here we go. Let's do. Okay. Yay. Unmute it. And it's all queued up, ready to go. Okay, cool. Let's do it.
And I believe The parties are calling a witness out of order, is that correct?
Yes, Your Honor.
All right. Although Dr. Oziel is still on the witness stand and will be resuming the witness stand for further examination, the people at this point are calling another witness who will testify this morning. And when he completes his testimony, then we'll resume with the examination of Dr. Oziel. You may call your next witness.
People call Dr. Jeffrey Lulow to the stand.
Okay.
Please raise your right hand.
with an affirmation.
You can do that, raise your right hand. You can solemnly affirm that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth. This you do under the pain and penalty of perjury.
I do.
Please take a stand and state your name for the record.
My name is Jeffrey Lulow.
Spell your last name, please.
Lulow.
And your first name?
Jeffrey, Jeffrey.
All right.
Thank you.
Looks
Dr.
like John
Lulow, what
Lovitz.
do you do for a living, please?
I am a psychologist
How long have you been a psychologist?
for 20 and a half years.
Excuse me, 20?
20, yes, sorry.
And in the period of time, 1986 through 1989, where were your offices located?
At 450 North Bedford Drive, suite number 203 in Beverly Hills.
Oops, sorry. My bad. I took out my earbud.
On Halloween night of 1989, did you receive a phone call from someone that was known to you?
Yes,
And do you remember about what time of day it was that you received the phone call?
I may have received several phone calls. You referring to a particular one?
Yes, a phone call from Dr. Jerome Oziel.
I don't remember the time. I do remember it was dark and was after my children had returned from trick-or-treating.
Now, at the time, did you have small children under the age of about 8 or 9?
Yes,
Had you taken them trick-or-treating?
yes,
You were aware of the fact that it was Halloween?
I was aware.
Right. And when you got this phone call, do you remember where you were inside of your home?
No. I remember where I was sitting when I was speaking on the phone, but I don't remember where I was when the phone call came.
From where did you speak with Dr. Oziel in your home?
I had a phone at my desk in the living room.
And did you have a conversation with Dr. Oziel on the night of Halloween of 1989?
Yes, I did.
And at that time of 1989, approximately how long had you known Dr. Oziel?
I had met him in June of 1986, so that would have been about 3 years and a few months.
What did he say when he called you on the phone?
I don't remember the words specifically, but I do remember that he informed me that he called because he was concerned about an issue that touched on ethics and wanted to know if I could talk to him about it and see if I could help him out with it.
Then what happened?
I told him that I'd be happy to talk to him, words to that effect. And he told me that he did not want to tell me too much because he didn't want to betray a confidence that he had received in the course of his practice. And he did not want me to become involved in something that might potentially become dangerous.
Well, that worked out well.
When you began to speak to him, did you notice anything about his demeanor over the phone? Did you notice anything about his tone of voice or anything like that?
Yes.
What did you notice, please?
I noticed that he spoke with some urgency. His words were clipped. There was some pressure of his speech.
After he told you that he didn't want to give you too much information, what next transpired during this conversation?
He told me that he had been seeing a young man who had told him that he and his brother had killed somebody.
Then what happened?
He asked if he had told me too much, if that was something that made me think I knew what he was talking about. And I said no.
Let me ask you a question. On August the 20th of 1989, approximately 2.5 months before, did something happen of significance in your own life?
Yes.
What?
My father died.
And at that time that your father died on August the 20th of 1989, were you present in the hospital?
I was present in the hospital for most of the week before that and dealing with the funeral for most of the week after that.
Did you read the newspapers during the period of time, the week before and after your father's death?
Apparently not. I don't remember too much else that I did. I went to the office when I could, and I dealt with the family matters of my father's house. And I don't remember too much else about that time. Apparently, I wasn't reading papers.
When Dr. Oziel informed you that he'd had a patient who had made this statement that you related to the jury, did you connect that up with anything you'd heard about in the media?
I hadn't heard anything in the media that, I mean, people are in the media being killed all the time, every day, unfortunately, and that didn't make any particular connection to me.
Okay, now after that, what happened next?
He told me that that one of these brothers had told him about having done this killing, and that the other brother, who was older, had come to his office apparently later, after he had first heard about this, after Dr. Oziel had first heard about this, and that there had been some talk at the office as to concern on these brothers' parts as to whom Dr. Oziel might tell about this, that it was no longer safe for them, that he had told somebody, and he had told them that because of the ethics under which he worked as a psychologist, he would not be able to tell anybody, and that he would not.
All right, then what happened?
He was concerned about two issues. Again, this is a phone conversation from 1989, so I remember the gist of it, but not the exact words. But I remember there were two issues he was concerned about.
And what were those two issues?
One.
Excuse me, I object to the question is made. Is he giving his impressions or what Dr. Oziel said to him?
All right, can you clarify that, please?
Okay, did you have discussion with him on two particular subject matters that you specifically recall?
Yes.
And what were the two subject matters that you specifically recall?
One had to do with his ethical responsibilities and the ethical constraints on him in such a situation. And the other had to do with his own safety and the safety of his family. Did
you and he address the issue of the ethics?
Yes.
And what was the conversation and what was your advice?
He brought up a case called Tarasoff, which has to do with warning intended victims of violent crimes.
Now, at the time that he brought up the case of Tarasoff, were you familiar with the Tarasoff case?
Every psychologist has to be familiar with the case. I was very familiar with it.
And could you briefly tell the jury what your understanding of Tarasoff was in 1989?
I'm sorry, I didn't hear you.
Could you briefly tell the jury what your understanding was of the Tarasoff case?
Tarasoff case, as I understood it, required, the outcome of that case required that a psychologist or other mental health professional take steps to warn the intended victims of violent crimes of their danger, and to alert the police or other law enforcement agencies that might be of help in preventing such a crime from being taken place. This was expanded in a later decision to include people who might potentially become harmed if this act is carried out.
All right. And
that was the Headland case.
In the Tarasoff case, did that deal with danger to someone other than the psychotherapist or the patient?
Yes.
Did it deal with danger to a third party?
Yes, it dealt with danger to a third party.
And did Tarasoff indicate that if a psychotherapist did not warn a third party of an impending danger, that the heirs of that third party, should the third party be killed, could sue the psychotherapist?
That was my understanding, although I'm not an attorney.
All right. But that was your understanding as a psychologist, correct?
That was my understanding.
And you are, in fact, a psychologist and not a psychiatrist.
I'm a psychologist.
Okay. What else did you talk about with Tarasoff with Dr. Oziel?
Well, he and I were discussing whether that case and the Headland case that I mentioned that expanded that to people who might reasonably be in danger applied when the intended victim is the psychologist or the therapist himself.
What else did you talk about?
Well, I said that I thought that it certainly was not going to extend more protection to someone else than it would to the therapist and his own family. And that I thought that the requirements of Tarasoff, in my opinion, as a psychologist, applied in this case, and that he could legitimately take steps to protect his safety and the safety of his family if he felt them to be in danger.
What else did you talk about?
We talked about what he could tell the police should he contact the police.
Now, who brought up the idea of talking to the police first, you or him, as best you can recall?
I don't recall.
All right. And so there was a discussion as to whether or not the police could be informed. Is that correct?
Yes.
And did you give him any indication as to whether or not he could ethically go to the police?
Yes, I did. I suggested to him that he could talk to the police, but he could not divulge to them the content of his discussions with these men beyond what was necessary to protect himself and his family.
Okay. Did you and he go into any details about how much detail he could tell the police?
I didn't want to know any more detail, so we didn't go into more detail.
All right. Did Dr. Oziel give you any indication about whether or not he wanted to go to the police or how he felt about that? Or did you have any further discussion along these lines?
Yes, we did.
I'm going to object to this, Your Honor. I said hearsay with no foundation.
Overruled.
We did talk about that. Dr. Oziel expressed the concern, a couple of concerns. One was that the police might not take it seriously enough, and secondly, that whatever protection they might offer would end at some point and that he and his family would still be in danger, potentially.
What else did you talk about?
I'm going to object to that, Your Honor. Calling for hearsay, no foundation.
Be more specific, please.
All right. I believe you indicated that Dr. Oziel had two concerns. One was ethical concerns and one was suggestions as to his safety. Is that correct?
That's correct.
Did you have any further discussion with him about the ethics of what he could do?
No.
All right. Did you have any further discussion about suggestions as to protective measures he might be able to take?
Yes.
Okay. And what else did you talk about in addition to talking about the police?
I'm going to object to that also, Your Honor. It's hearsay with no foundation.
Objection overruled.
I made a suggestion to him as to something he might do that would not violate the confidentiality of the discussions with these men and might also serve to protect himself and his family.
And what did you suggest to him that he do?
Well, I suggested a few things.
What's the first?
The first thing was that he tell his wife to take the kids and go on a vacation immediately.
Okay. What else?
That he hire someone to watch the house.
What else did you suggest?
That he hire someone to watch him, protect him, bodyguard.
Did you use the term bodyguard?
Yes, I believe so.
What else did you tell him to do?
I suggested that he write down in detail everything he had told me, plus whatever he had learned in the sessions from these men, that he put it in great detail, that he dated, that he put that writing in a safe deposit box.
Did you tell him what to do in regards to the safe deposit box?
Yes.
What did you tell him?
That he provide his attorney with a key to the box, with the right to open the box, that he sign whatever he needed to do to let his attorney open the box, that he also direct his attorney that if anything should ever happen to him or his family, that the attorney was to open the box in the presence of authorities.
Did you give him any suggestion as to whether or not he should convey these measures to the people who had threatened him?
I specifically suggested that he tell these men that he had done that, so that with the idea being that they would recognize that his safety was their concern, that they would be better off if he were safe, but also indicating that by doing it in this way, he had not divulged the confidence.
Now, at the time that you had this conversation with Dr. Oziel, do you recall if all the Halloween activities were already over?
We always had stragglers coming in trick or treat. They always seemed to be older than the kids who came earlier, and so we had people coming to the door now and then.
Was that after the phone call with Dr.?
This is irrelevant.
It's just pin the time, Your Honor.
Overruled.
I don't recall precisely if anybody did come on that night or not. We generally did, but I don't know.
All right. Dr. Lulow, when was the first time you were contacted by any of the attorneys in this case regarding the activities of Halloween of 1989? And by whom were you first contacted?
I was called on, if I can look at my appointment book, I can probably tell you the day.
All right. Do you have your appointment book?
Yeah. I believe it was Wednesday, August 4th.
Do you remember who it was that called you?
I didn't get his name completely. Mr. Burke, is that the name? Represents Lyle Menendez, he told me.
All right, and that was the first phone call you've gotten from any of the attorneys in this case, is that correct?
That's correct.
And then you were called subsequently by either myself or someone on the prosecution team, is that correct?
That's correct.
So your first contact then was from the defense, correct?
That's correct.
Now, how was it that you knew Dr. Oziel?
I have a concern that divulging that may violate a confidence. I'd rather that the court tell me whether or not I can divulge that.
Does this have to do with probationary status of Dr. Oziel?
Yes, it does.
Okay, you may.
I'm ordered to do
Yes.
so. Thank you, Your Honor. I was selected by Dr. Oziel to supervise him when he was on probation with what was then called the Psychology Examining Committee, and now is called the Board of Psychology.
And in that regard, were you employed by the Board of Psychology to conduct the supervision, or how were those arrangements made?
The Board of Psychology apparently provided Dr. Oziel with a list of psychologists from whom he could select someone as his supervisor. He selected me, and he would be paying me for the time involved in the supervision.
Did you first meet with him in June of 1986 in regards to his probationary status?
Yes,
And did you conduct interviews or sessions with him for once a week for a period of a year after that?
yes, I did.
What was he on probation for?
Again, Your Honor, is that something I can answer?
Yes.
He was on probation for what's called a dual relationship. He had had a relationship with a patient, and it.
Your Honor.
Okay, let's hold on. We're having some electronic problem here.
Electronics in the courtroom.
Is it possible we can get some water?
Sure. Get a little water for you. Well, how is the reporters? Well, we're working now, Lynn, or?
Does microphone need to be positioned differently?
No, you're okay. It's just some hearing device for one of the jurors. You okay? Okay, let's go. All right, you may resume your examination.
I believe the question was, what was Dr. Oziel on probation for? Could you factually explain what it was?
He had a patient whom he was seeing, who said he was unable to. Thank you. Unable to pay Dr. Oziel's bill. And after some discussion with this patient, Dr. Oziel had arranged with.
At this point, I'm sorry. You can do it. I'm going to object to this as hearsay.
Details of it are sustained.
Okay. Did Dr. Oziel tell you?
Your next
Dr.
question.
Oziel tell you what he was on probation for?
Again, Your Honor, is that something I can divulge?
Yes.
Dr. Oziel did tell me what he was on probation for, but I had also received documents from the Psychology Examining Committee telling me.
And did he was on probation for having a patient do work on his home in lieu of paying for services, is that correct?
Objection, Your Honor, that's insane.
Sustained.
What did Dr. Oziel tell you he was on probation for?
Objection, hearsay.
Prior consistent statement.
Okay, counsel, let's not argue the matter. The objection is that this is hearsay. It's being offered for the truth, is it?
Yes, as a prior consistent statement.
All right, the objection is overruled. You can answer the question.
Okay.
Dr. Oziel told me that he was on probation.
Oh, sorry.
Wait,
Well, let me answer.
I forgot what the question was.
Okay.
Okay. Well, let me get this question real quick because so Debbie Faison Cook asked, so this hearsay is allowed because it impeaches Oziel. This is from a little bit ago, but it's similar statements from before when she picked this up. So this is what's going on here is he's getting into what Dr. Oziel told him about his probationary status, right? And so normally that's an out-of-court statement that is offered for the truth of the matter asserted. So this should be hearsay. But the reason that it's being introduced in court is for a prior consistent statement, meaning this witness now, as a result of, not this witness, Dr. Oziel, the other witness, through his cross-examination, there were impeachments, there were all kinds of questions and answers that showed that he was being inconsistent with a lot of his testimony, including this part. So when that happens, you're allowed to also introduce a prior consistent statement. So basically to show like, no, this witness was actually telling the truth during this. You're allowed to like rebut that in the next instance, basically. I hope that makes sense. Shibaka Wookie says, I have a question that has nothing to do with this. Why do civil cases have time limits unlike criminal trials? I think they do also have time limits for criminal trials, but I think part of it is because you've got Andy. Yes, I did say but. Nice to see you in the chat, Andy. So civil cases are put on by attorneys who are very often paid by the hour, but sometimes also paid on a contingency fee basis. But because they tend to be put on about money and these kinds of things, I think there's a tendency to overbill, to over like drag these cases out. Criminal cases, you've got the state, they have a very impacted docket. The prosecution usually doesn't want to drag out a case. They have no reason to, because they have so many other cases that they want to get to. And okay, yeah, and you can't violate constitutional rights. So there is a possibility that you could run into issues with timing in a criminal case and the constitutional rights, right? Yeah, because the defendant does have the right to a full, fair, and speedy trial. However, I do believe that there is some amount of timekeeping, some amount of time management in a criminal case nonetheless. But there's, I think, a little bit of a less of an emphasis on it than there is in civil cases. Okay.
I was answering some other question.
Very briefly. What did Dr. Oziel tell you as to why he was on probation?
He had a patient of his do some work on his house while the man was still a patient.
In lieu of being paid money?
In lieu of paying Dr. Oziel's fee.
Did you write 4 quarterly reports on Dr. Oziel's behalf?
Yes, I did.
Overruled.
And were these reports favorable?
Objection, hearsay.
Sustained.
Did you recommend the successful completion of Dr. Oziel's probation?
Objection, hearsay.
Sustained.
May I make an offer?
Yes, you can do that at the sidebar.
Yes.
All right, you may continue your examination.
Dr. Lulow, I believe you indicated that you first met Dr. Oziel in June of '86. Is that correct?
That's correct.
Now, in October of 1989, jumping ahead some period of time, how long had it been since you had seen or heard from Dr. Oziel?
I had heard from him, I believe, the previous summer, but I don't remember when. 1989.
Okay, and prior to that, how much contact had you had with him?
I had not heard from him since I stopped supervising him in June of '87.
Okay, I have no further questions of this witness.
Cross-examination.
Dr. Lulow, I noticed when you were asked the question of when you and I spoke, you had a book in your hand that you looked at, and you then gave us the date of August 4th as the date when you and I spoke, correct?
Are you Mr. Burke?
Yes.
Oh, okay. I don't know who you are.
I'm sorry. I'm Mr. Burke.
Yeah, that was my best estimate. I don't enter it in the book. I was trying to remember by whom I had seen that day. So it may have been the day before or the day after. I don't recall.
Did you make any notes of the conversation you say you had with Dr. Oziel?
Which conversation?
Well, the prosecutor questioned you about a conversation on Halloween, and you explained how you were out with your kids trick-or-treating. So that's the conversation you're here to testify about.
Okay.
And my question was directed to that conversation.
Made no notes.
Made no notes. And you at that time were Dr. Oziel's, in effect, probation officer, were you not?
I, at that time, had no connection with Dr. Oziel whatsoever.
When did you become Dr. Oziel's probation officer?
Well, I was never his probation officer. I was his supervisor.
He was on probation.
That was not a matter between him and me. I was his supervisor. That was the role that I served.
Was he on probation? Was that your understanding?
I don't recall the details of that, whether it was probation or whether his license had been revoked and it was stayed. I don't recall the details.
Well, what was your understanding of what you were supposed to be doing with him?
My understanding, during the time that I was supervising him,
Yes.
I was supposed to be, in effect, monitoring his practice, both in terms of the nature of what he did in his practice and any ethical considerations that came up, and reporting to the Psychology Examining Committee quarterly regarding these meetings.
And was it your understanding of your relationship with Dr. Oziel that he was going to be looking to you for advice on certain ethical questions that he might have?
During the time that I was supervising him?
Yes.
Well, he could look to me. He could actually talk to any of a number of people. These sessions were a weekly thing, so it was an easy thing if there was an ethical question that came up to ask me about it and to discuss it with me.
And I think you said you first began seeing him on probation on June 2nd, 1986. Is that?
I don't recall the date that I did it. It was in June of '86. I do know that.
And when did you stop seeing him?
It was a 1-year period of supervision that he had to have. So I believe it was either the end of May of '87 or the beginning of June.
And after that period of time, I think you indicated you had no further contact with him. He never called you again?
He didn't call me until sometime in the summer of '89, I believe it was. That's an imprecise time in my mind.
So after your involvement with him in May of '87, the next time you heard from him was in the summer of '89?
That's correct.
And was that the telephone conversation on Halloween night?
No, Halloween's in the fall.
That's true. What was the conversation you had with him in the summer?
He asked if I could refer him to psychiatrist or psychologist to help him with the matter that he was involved in.
And did you in fact refer him to a psychiatrist or a psychologist?
Both.
And who did you refer him to?
Dr. Franklin Drucker, psychiatrist, and I believe Dr. Bruce Sutkus, Sutkus, a psychologist.
And then the next time you heard from him was in October of 1989?
That's correct.
Now, have you been in contact with him since that conversation in October of 1989?
I believe I had, you asked me this on the phone, and I said at the time, and what I said at the time to you was that I'm not clear. I think I did have one further conversation, but I don't remember it. I don't remember anything about it except that I talked to him, and I think his wife was also on the line.
And have you seen him socially at all since then?
I never saw him socially ever.
We're not friends.
This information you say you gave to him, you told him that his wife should go on vacation. Is that right?
I suggested that his wife and children, whoever was in the household, should go somewhere else until things had settled down, yes.
And by the way, that's not information you provided to me when you and I spoke, was it?
I answered all your questions when you asked them.
By the way, that's not information you provided to me when we spoke, is it?
No, I didn't give you any information you didn't ask for.
And again, once again, you did not give me that information that you told him that his wife should go on vacation. Yes or no? It's very simple to answer.
No, as I said before,
Thank
no.
you.
Oh.
And you didn't tell me in that conversation that you advised him to get a bodyguard, did you? Yes or
I
no?
don't recall whether I told you that or not.
Did you tell me in that conversation that you advised him to write down in detail everything he did?
I don't recall what your questions were. I know I answered your questions. I don't recall whether you asked me that or not.
You recall telling me that there were certain things that you would not discuss with me?
Yes.
And was this one of the things you didn't want to reveal?
I didn't think that I could talk about the content of any of my supervisory sessions with Dr. Oziel.
Right, but
That's what I had in mind when I said that to you.
Yeah, but you were free to tell that to the prosecutor. Is that
Free to
your
tell
understanding?
what? I'm sorry, free to tell
You
what?
were free to tell the prosecutor that information?
Of course not.
Didn't you meet with a prosecutor before you came to court
Yes.
today?
Yes.
And didn't you tell her this information that you just revealed to the jury?
Could we have it clarified what information you're talking
The
about?
information about advising Dr. Oziel to get a bodyguard?
You're mixing two things up.
Did you tell her the information about advising Dr. Oziel to get a bodyguard? Yes or no?
Yes, I did.
All right. And did you
Yikes.
tell the prosecutor the information about advising Dr. Oziel to write down in detail everything he did?
Yes.
Did you tell the prosecutor that you advised Dr. Oziel that the police could, in your opinion, be contacted under the Tarasoff decision?
I think I said, yeah, I told her that. I think I told you that too.
All right. Now, was it your understanding when
Wow. So that was really good because that indicates that this witness is not exactly unbiased. He's being very open with giving information to the prosecution, not so much with the defense. So this definitely gives an appearance of bias right there.
when Dr. Oziel called you that his ethical dilemma was he wasn't sure that Tarasoff extended to a situation that involved a threat to the therapist himself?
That was part of his concern.
Right. Did he indicate any misunderstanding that Tarasoff did or did not apply to a threat to someone else?
My recollection is that he understood that Tarasoff applied if someone told him they were going to do harm to somebody else, period. And that under those conditions, he had a duty to warn the person. But when the threat was to himself, he was unclear.
All right. So if the threat was to a third person, at least based on your discussion with him, he understood that it applied there. The ethical question was, well, what about if the therapist is threatened?
That was one part of the ethical question. The rest of it was what could he divulge in order to protect whoever had to be protected. Some of this was really an airing of views more than seeking my word. I didn't have any authority to tell him. It was just airing the views and getting my suggestions.
And you basically, if I understood your testimony correctly, told him that he could divulge to the police whatever was necessary to protect himself or his family, correct?
Only that which would be necessary to protect
Himself and his family.
Yes.
And he never discussed with you that there was anyone else involved besides himself and his family, did he?
I think he had a housekeeper. I kind of assumed that person, if he did have a housekeeper, would be included at the household.
In other words, he mentioned that there was a housekeeper that may have been in danger as well.
No, he didn't at that time. But when I was supervising him, he had mentioned the presence of a housekeeper. So when I talked to him in '89, I figured there might be a housekeeper. So that person was in my mind as well.
And did you mention that? In other words, as you were discussing the situation, did you say something along the lines of, well, you can do whatever it takes to protect yourself, your family, your housekeeper, whatever?
No, I never said you can do whatever it takes. I never said that.
Did he mention to you that he had a girlfriend that he was worried about?
Never heard any mention of girlfriend.
Did he mention to you that there was a girlfriend sitting in the room with him as he was discussing the confidential information that he was discussing with him?
As I just said, there was no mention of girlfriend in any relationship to anything at any point, at any time between Dr. Oziel and me in that conversation.
And so he never mentioned any ethical problem with regard to divulging any information to a girlfriend or anybody like a girlfriend, right?
I think that goes without saying based on my last response.
All right. You can just answer the question. Okay.
I think I did.
Good. Thank you. Now, did you indicate that Dr. Oziel said to you that he had told the patients that he couldn't tell anyone what they had told him?
That he had told them that he couldn't tell anybody about having told him they had killed somebody.
Basically, he explained to you that he had explained to the patients that what they had said was confidential.
Yes.
And that was all he said about what he had explained to the patients about confidentiality, right?
That's correct.
So he didn't tell them that he would have to tell the police or someone else about this.
And when you and I spoke on August 4th, did I tell you that for the first time since this litigation began in 1989, Dr. Oziel mentioned your name for the first time in testimony here before this jury?
Objection, hearsay, irrelevant, what he said.
So for a non-hearsay purpose. Were you aware that your name came up in this case for the first time the other day in front of the jury?
I have no idea when my name came up or didn't come up.
And prior to my calling you on August 4th, did Dr. Oziel ever contact you and say, I want you to testify in a hearing or before a court to explain to the court that you were the one that came up with this idea about?
Never. I haven't spoken with Dr. Oziel for years.
And do you know if Dr. Oziel followed your advice that you gave to him
I
about
do
hiring a bodyguard? And
I do not know.
thank you. That's all I have. Dr. Oziel ever express any concern for his business partners?
Objection, Vegas, is October 31st.
October 31st.
I don't know whether he had business partners nor whether they were threatened.
So you don't have any specific recollection of him saying to you, I got people in this office who are also threatened. What do I do about them? Words to that effect.
I don't remember him saying words to that effect.
Do you know who supervised Dr. Oziel for the remainder of his probation?
I don't know whether there was any remainder of the probation.
What was your understanding as to how long the probation was when you were dealing with him? Was it 5 years?
1 year.
I think that I'd object to hearsay.
Overruled.
My understanding was that I was to supervise him for 1 year.
What did you do to supervise him?
I met with him weekly, discussed, without divulging any details of that had been given to him, issues that may have come up in his practice that were ethical, discussed some ethical issues that may have come up in my practice as illustrations. That was what we did.
And then he was to pay you a fee for your time,
Certainly,
is the way that worked.
certainly.
Thank you.
Ms. Aberson.
Thank you. Dr. Lulow, as part of the discussion that you had with Dr. Oziel, did you advise him to tell these patients, these particular two patients, that since confidentiality was limited and since they had threatened him, there was no further confidentiality?
Let me think. I know I didn't say that.
Wouldn't that, in your opinion, have increased any potential danger, assuming there was any?
Objection calls for speculation.
Did you have any such opinion at the time?
I did not have the opinion that confidentiality had gone out the window with the threat. That was not my opinion. Again, I'm not an attorney. I'm a psychologist trying to deal with a problem with another psychologist.
I'm trying to focus you, though, on the advice that you gave Dr. Oziel about how to take some measures to make himself feel safer, okay?
And he has
You had
thoughts.
suggested that he write detailed notes, that he put them in a safe place, that he give an attorney access to them, correct?
Correct.
And you also advised him that he should tell the patients, basically, I have these notes, therefore it's in your best interest if nothing bad happens to me, in effect.
In effect.
And he told you that he had assured the patients of confidentiality, and that too was a safety effect, was it not?
He told me that he had assured them of that, but my understanding from what he told me was that he assured them of that before the threat was made.
Okay. And did he tell you that he had no further conversation with them about confidentiality after the supposed threat was made?
I'm sorry, there was a cough that I couldn't hear.
Did he tell you that there was no further discussion about confidentiality after the supposed threat was made?
We didn't talk about anything else about that session or sessions he'd had.
Okay. You were supervising him to monitor his ethics. Is that right? Because his violation was an ethical violation.
Yes.
You weren't there to supervise his competency, were you?
Well, only as ethics touch on competency, of course.
Okay. But you weren't, for example, privy to his patient notes. You weren't reviewing whether his therapeutic contracts or assessments or diagnosis or therapeutic plans for each of his patients were fit the standard of care for competent practice.
Only insofar as that information, in a very vague sense, became relevant to discussing ethical issues.
Do you recall how many patients Dr. Oziel had in 1986 through 87 when you supervised?
Patient calls for hearsay relevant.
Overall.
I have no idea how many patients he had.
Were you aware in 1987 that he went into business with a patient?
Objection calls for hearsay.
You're asking if he's aware.
Hearsay.
Objection overruled.
I know nothing about going into business with a patient.
If he had gone into business with a patient, would that have caused you some concern given the fact he was on probation for a dual relationship?
It would have given me concern for anybody, whether or not they're on probation. You're not to do that.
Ooh. Bum, 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 bum.
Now, when you and Dr. Oziel were discussing
That look on his
Parasol-
face,
well,
hang on. That look on his face right there was like, oh shit, what is this guy getting me into? That's the look on his face right now, in my opinion. I don't know. Do you guys see it differently? That's what I'm seeing.
we'll strike that. You've testified you told him he could divulge to the police what was necessary to protect himself. Now, that's the standard of Tarasov, isn't it? You divulge what is necessary to protect.
That's my understanding.
Okay.
Yes.
And Tarasov basically is the case that established civil liability, the ability to be sued and pay money if a therapist fails to warn a third party that they have been threatened by a patient.
That may be its import for the law. The import for psychologists is you've got to warn and you've got to protect.
Okay, but it has two impulses. One is what Tarasov really said was if you don't warn, you can get sued. You can be held responsible.
That's a legal understanding of it. My understanding was you got to warn, you got to protect people.
Okay, you also have to have malpractice insurance, don't you?
I don't believe you're required to.
But I'm saying if you're concerned about Tarasov, that's a concern that leads to malpractice insurance because you could get sued for a lot of money.
I don't know. I have malpractice insurance because I think it's a good thing to have.
Okay. Do you know if Dr. Oziel had malpractice insurance?
Irrelevant.
Sustained.
Now, you told him to write detailed notes. Did you intend that he should write notes that were accurate?
Certainly.
And is it your understanding as a psychologist that notes are likely to be most accurate when they are written closest in time to the events that they detail?
Objection beyond scope.
Overruled.
Yeah.
It's an interesting question. It actually has two parts to it as far as a psychologist is concerned. With respect to the actual words that are said, it's probably, I'm sure it's more accurate closer in time. But in terms of an understanding of the import of what somebody says, very often that becomes clearer as time passes.
And as you have more contact with the person. Is that
Well,
right?
sometimes just thinking about it.
Okay.
Sometimes just having your own experience that touches on the issue.
But the practice of keeping notes, psychologists keeping notes, okay, is there some ethical notion that they should be an accurate reflection of what goes on with a patient in a therapy session?
Well, again, there's two questions there. I'm not aware of any requirement regarding the keeping of notes. That's an issue that is being hotly debated in psychology at present. What standards, if any, should there be for note-taking? But certainly, I think it's only reasonable to require that any notes that one takes be accurate.
Did Dr. Oziel indicate to you that he was going to follow that piece of advice and sit down and write detailed notes?
He said that he thought it was very good advice and that he was going to do that.
Are you familiar with any of the research in memory and the retention of memory over time?
Your Honor, this is beyond the scope.
Objection sustained.
Did Dr. Oziel indicate to you before you got off the telephone with him that night that he was going to call the police?
I don't recall whether he indicated that he would call the police or not.
Thank you. I have nothing further.
Any redirect?
Just briefly, Dr. Lulow, I believe it was your testimony on cross-examination that you did not make any notes of this conversation. Is that correct? The one from October the 31st?
That's correct.
And yet, do you remember the conversation?
Okay.
Argumentative.
Overruled.
I do recall the conversation.
How come?
It was a dramatic conversation. It was reinforced in my memory when I saw a news report on CNN in March of 1990.
Was this a unique type of conversation for you to have with another psychologist?
Was unique till yesterday when I had another such conversation.
But up until yesterday, was this a unique experience for you?
Up till yesterday was unique.
Thank you.
Anything else?
You say you saw something on television which reinforced the importance of this in your mind.
Yes.
Did you at that point think it was important enough to come forward and tell people you had some information regarding this case?
Did I think it was important enough to cause two questions? I thought it was important. I didn't think that I as a matter of fact, I was watching CNN with my attorney, and my understanding was I had no responsibility to do anything at that point.
Or at any point?
At any point. Except to come here when I got a subpoena.
True.
Now, I want to clarify one thing. Did you tell Dr. Oziel that he should write down immediately his impressions?
I don't recall whether I
Beyond the scope, Your Honor.
Overruled.
Yeah.
I don't recall whether I suggested a time frame. I suggested a course of action that at the time I thought made sense.
And in terms of the conversation you had with him in this specific situation, you testified that sometimes your impressions as a therapist will get better with time. Is that the same situation as someone who comes in, say, and threatens, and you're trying to document what the circumstances are of that threat?
If you're
Or are you talking in terms of a diagnosis or evaluation?
Right. I'm saying that what I said was that I think that in terms of the specific things that were said, it's probably more accurate right after. If that's what I'm doing in my notes, then I would want to do it right after. If what I want to do is try to understand it, I might not want to write anything down for a little while.
Okay. And so in a situation, say, where there's a threat made, because of the ethical ambiguity of what a therapist can do, it might be important to sit down and get the actual words of the threat down right away, because that's something that maybe is going to come into play later in terms of what the therapist does in terms of warning and disclosing and whatnot, correct?
I don't know. My understanding is I'm not here as an expert witness on memory. I would write it down right after.
All right, anything else?
No.
Okay. Thank you. You may step down. You're excused.
All
Let me
right.
see counsel at the sidebar regarding the next examination. Sure. All right, we'll take a recess then, ladies and gentlemen, until 11 o'clock. I was just conferring with the attorneys regarding the scheduling and as far as what we're next doing here. And since there is going to be some examination of Dr. Oziel before only one jury and not the other jury, I was trying to ascertain from the lawyers when precisely we'll do that. But there is still further examination of Dr. Oziel before both juries. And
Okay.
because of that, we'll proceed with that next. And that will be examination by the prosecution called redirect examination. So we'll take a recess and we'll resume at 11 o'clock. Don't discuss this case with anyone. Don't form any final opinions about it. And we'll resume at 11 o'clock. juries are not yet present. Council had a matter that
Okay.
they wanted to discuss
this,
before the
I
juries
believe,
come
is
in.
all going to be argument in front of the judge, so we can
That
flip
she
through it.
forgot.
Yeah, I think this is going to be the end of the session.
Wonderful husband.
Great. Okay. Yes. So, okay. Yeah, that was a nice little addition there. So, thanks for sticking with me for that. So interesting. It was interesting to hear from his supervisor, who definitely, I think, came across as like, man, I'm only here because, or I was only involved in this guy's life because he was already in probation. He already was doing this stuff. And he didn't tell me this other stuff. Was like, that was the impression that I had, was that he's like, he didn't tell me that he had this other girlfriend that he was also maybe giving medical care to, that definitely would violate our ethics. And then some of the other questions, like, you could just see his demeanor change, that he's just like, I mean, that would absolutely not be okay, whether he's on probation or not. So yeah, so that was very interesting. So next week, Monday, unless there's some kind of a pop-up trial that happens again, we will be back on at 10 o'clock East Coast time next Monday as well, for more classic trials, more Menendez Mondays. And it sounds like it's going to be back to Dr. Oziel again. after 4 parts of that, we're apparently not finished with him yet. So there will probably be more spice, more fireworks when it comes to him. And yeah, crazy. But thank you so much, folks. And I see your member chat, Sandra Ramirez, in the chat says, thank you so much, Alita. Thank you. And also, Sandra, thank you so much for gifting 5 Legalbytes memberships earlier. And to those folks that are now part of Bite Club, welcome to Bite Club. On Fridays, we have a members only live stream. So it's just a casual hangout Friday, 10 o'clock East Coast time, unless I have some kind of a travel thing that's happening that I might shift it to the right or to the left. But usually Friday is the center of gravity at 10 o'clock East Coast time, same time that this stream starts as well. So yeah, I hope you can make it for that. And okay, well, that for me about does it. Thank you guys. This has been another fascinating installment of the Menendez trial for classic trials. And I'll see you guys in the next video.